Honorable Excellencies that have joined us today to be here with us. It is indeed an honor to be here. Welcome, everyone. Thank you so much for taking out your time to be here with us today. We'll start shortly, but before we start, I'd just like to pass the floor to Senki and Mr. Fon, just to check if everything is all right on their side before we go ahead.
Yes, Daddy, I think you can start it from now and just start with announce with agenda for the participant. Yeah.
Okay.
Yeah.
All right. So yes, so we can start. So first of all, I'd like to welcome once again. This is the World Intellectual Property Organization in partnership with Cambodia Trade and the Ministry of Commerce in Cambodia. It's an honor to be here with you all. I'll first like to pass the floor to Her Excellency Ms. Tekrith Cameron, Secretary of State, Ministry of Commerce, to give us the opening remarks, and followed by Dr. Andrew, who will start next. Thank you so much.
Thank you very much, and good afternoon from Cambodia. Allow me to give my speech in Khmer because of our participant is almost Cambodians. ជាដំបូងសូមគោរពអាយដាមក្នុងទីនេះមានវត្តមានអាយដាមអង្គការពិចិត្រអគ្គរដ្ឋទូតប្រចាំអង្គការពាណិជ្ជកម្មពិភពលោកនិងអង្គការអន្តរជាតិពាក់ព័ន្ធនឹងវិស័យពាណិជ្ជកម្មលោកបណ្ឌិត Andrew Michael Ong ប្រធានទទួលតំបន់អាស៊ីប៉ាស៊ីហ្វិករបស់អង្គការកម្មសិទ្ធិបញ្ញាពិភពលោកលោកតាន់ជីមីងមន្ត្រីជាន់ខ្ពស់ទទួលបន្ទុកតំបន់អាស៊ីប៉ាស៊ីហ្វិករបស់អង្គការកម្មសិទ្ធិបញ្ញាពិភពលោកលោកស្រីជាវាគ្មិនអញ្ជើញមកពីនាយកដ្ឋានកម្មសិទ្ធិបញ្ញានៃក្រសួងពាណិជ្ជកម្មនិងអញ្ជើញមកពីអង្គការកម្មសិទ្ធិបញ្ញាពិភពលោកតំណាងសហគ្រាសធុនតូចនិងមធ្យមកម្ពុជាដែលបានចូលរួមនៅក្នុងសិក្ខាសាលាថ្ងៃនេះជាទីគោរពរាប់អានថ្ងៃនេះក្នុងនាមអាយដាមបានសូមសហរដ្ឋមន្ត្រីក្រសួងពាណិជ្ជកម្មខ្ញុំមានសេចក្តីសោមនស្សរីករាយដែលបានចូលរួមនៅក្នុងសិក្ខាសាលាស្តីអំពីការពង្រឹងការប្រកួតប្រជែងនិងការរីកចម្រើនផ្នែកធុរកិច្ចតាមរយៈការប្រើប្រាស់កម្មសិទ្ធិបញ្ញាឆ្លៀតក្នុងឱកាសនេះខ្ញុំក៏សូមសម្ដែងនៅការកោតសរសើរនិងថ្លែងអំណរគុណដល់ក្រុមការងារនាយកដ្ឋានសហប្រតិបត្តិការអន្តរជាតិក្រសួងពាណិជ្ជកម្មដែលដឹកនាំដោយលោកជាលេជាបានសហការជាមួយអង្គការកម្មសិទ្ធិបញ្ញាពិភពលោករៀបចំឲ្យមានសិក្ខាសាលាដ៏មានសារៈសំខាន់នេះសិក្ខាសាលានេះគឺជាសកម្មភាពមួយផ្នែកមួយនៃគម្រោងអភិវឌ្ឍពាណិជ្ជកម្មតាមប្រព័ន្ធអេឡិចត្រូនិកឬហៅកាត់ថា Go for e-com ដែលគម្រោងនេះមានគោលបំណងបង្កើនឱកាសសេដ្ឋកិច្ចសម្រាប់សហគ្រាសធុនតូចនិងមធ្យមនៅកម្ពុជាក្នុងការចូលរួមទាញយកអត្ថប្រយោជន៍ពីសេដ្ឋកិច្ច Digital តាមរយៈពាណិជ្ជកម្មអេឡិចត្រូនិកហើយបច្ចុប្បន្ននេះខ្ញុំសូមជម្រាបជូនថាយើងទទួលបានក្រុមហ៊ុនជាង100ហើយជិត200ក្រុមហ៊ុននឹងបានដាក់លក់ផលិតផលជាង 1000 មុខលើទីផ្សារអនឡាញរបស់យើងសម្រាប់សិក្ខាសាលាថ្ងៃនេះមានគោលបំណងចម្បងគឺបង្កើនការយល់ដឹងបន្ថែមទៀតជូនដល់សហគ្រាសធុនមីក្រូតូចនិងមធ្យមដែលបានចុះឈ្មោះនៅលើទី
who register on Cambodian trade to understand the importance
ការការពារការប្រើប្រាស់កម្មសិទ្ធិបញ្ញាដែលក្នុងនោះរួមមាន5ចំណុចធំទី1គឺម៉ាកនិងពាណិជ្ជនាមម៉ាកសម្គាល់ភូមិសាស្ត្រទំនិញទី3កិច្ចការពារព័ត៌មានសម្ងាត់ពាណិជ្ជកម្មទី4ការផ្ទេរអាជ្ញាប័ណ្ណនិងសិទ្ធិធ្វើអាជីវកម្មនិង5គឺកម្មសិទ្ធិបញ្ញាផ្សេងទៀតដោយអាយដាមដូចជំទាវលោកស្រីបានជ្រាបហើយថាវិស័យកម្មសិទ្ធិបញ្ញាគឺមានសារៈសំខាន់សម្រាប់អាជីវករអ្នកធ្វើធុរកិច្ចទាំងក្នុងនិងក្រៅប្រទេសជាពិសេសគឺសហគ្រាសធុនតូចនិងមធ្យមនៅក្នុងការគ្រប់គ្រងរក្សាការពារសិទ្ធិតាមផ្លូវច្បាប់នៅម៉ាកពាណិជ្ជនាមលើផលិតផលនិងទំនិញរបស់ខ្លួននិងចូលរួមលើកកម្ពស់ការប្រកួតប្រជែងដោយស្មោះត្រង់រដ្ឋាភិបាលកម្ពុជាក៏បានចាត់ទុកការការពារកម្មសិទ្ធិបញ្ញានេះមានសារៈប្រយោជន៍ក្នុងការលើកកម្ពស់វិស័យឯកជនទាក់ទាញការវិនិយោគទុនបរទេសនិងការផ្ទេរបច្ចេកវិទ្យាពង្រឹងសមារណកម្មសេដ្ឋកិច្ចទៅក្នុងតំបន់និងពិភពលោកនិងចូលរួមក្នុងការអភិវឌ្ឍសេដ្ឋកិច្ចកម្ពុជា នៅក្នុងច្បាប់ស្ដីពីម៉ាកនិងពាណិជ្ជនាមនិងអំពើនៃការប្រកួតប្រជែងមិនស្មោះត្រង់ដែលបានរៀបចំឡើងដាក់ឲ្យប្រើប្រាស់តាំងពីឆ្នាំ 2002 បានបញ្ជាក់ពីគោលបំណងគឺការពារម៉ាកពាណិជ្ជនាមដែលបានចុះបញ្ជីនៅប្រជាណាចក្រកម្ពុជានិងប្រឆាំងការប្រកួតប្រជែងមិនស្មោះត្រង់លើការបង្កើតការប្រើប្រាស់ម៉ាកនិងពាណិជ្ជនាមមាត្រា 3 បានចែងថាសិទ្ធិផ្ដាច់មុខនៅក្នុងការប្រើប្រាស់ម៉ាកត្រូវបានទទួលស្គាល់តាមរយៈការចុះបញ្ជីម៉ាកដោយអនុលោមតាមបទបញ្ញត្តិនៃច្បាប់នេះមាត្រា 22 ចែងថាអំពើនៃការប្រកួតប្រជែងដែលផ្ទុយពីគោលការណ៍នៃការវត្តទៀងត្រង់នៅក្នុងវិស័យឧស្សាហកម្មពាណិជ្ជកម្មសេវាកម្មត្រូវចាត់ទុកថាជាការប្រកួតប្រជែងមិនស្មោះត្រង់កម្មវិធីបណ្ដុះបណ្ដាលថ្ងៃនេះជាពិសេសផ្ដោតសម្រាប់សហគ្រាសធុនតូចមីក្រូនិងមធ្យមដែលបានចុះឈ្មោះលើទីផ្សារអនឡាញរបស់យើងដើម្បីស្វែងយល់អំពីមូលដ្ឋានគ្រឹះនៃការប្រើប្រាស់កម្មសិទ្ធិបញ្ញាការការពារដោយស្របច្បាប់លើម៉ាកនិងពាណិជ្ជនាមរបស់ខ្លួនហើយលើពីនេះខាសកម្មក៏អាចស្វែងយល់បន្ថែមពីមូលដ្ឋាននីតិវិធីក្នុងការចុះបញ្ជីម៉ាកការរៀបចំតម្កល់ទុកជាផ្លូវការនៅស្លាកសញ្ញាទំនិញដោយមានការប្រឹក្សាយោបល់ពីនាយកដ្ឋានកម្មសិទ្ធិបញ្ញានៃក្រសួងពាណិជ្ជកម្មនិងអង្គការកម្មសិទ្ធិបញ្ញាពិភពលោកផងដែរក្នុងនាមក្រសួងពាណិជ្ជកម្មខ្ញុំមានជំនឿយ៉ាងមុតមមថាកម្មវិធីសិក្ខាសាលាស្ដីអំពីការពង្រឹងភាពប្រកួតប្រជែងនិងការរីកចម្រើនផ្នែកធុរកិច្ចតាមរយៈការប្រើប្រាស់កម្មសិទ្ធិបញ្ញានេះនឹងផ្ដល់អត្ថប្រយោជន៍ជាច្រើនដល់សហគ្រាសធុនតូចនិងមធ្យមដើម្បីទទួលបានចំណេះដឹងថ្មីទាក់ទងនឹងវិស័យកម្មសិទ្ធិបញ្ញាការចូលរួមការពារកម្មសិទ្ធិបញ្ញាការត្រៀមខ្លួនជាស្រេចក្នុងការប្រើប្រាស់កម្មសិទ្ធិបញ្ញារបស់ខ្លួនប្រកបដោយប្រសិទ្ធភាពនិងប្រសិទ្ធផលជាពិសេសការធ្វើពាណិជ្ជកម្មតាមប្រព័ន្ធអនឡាញនេះជាថ្មីម្ដងទៀតខ្ញុំសូមសម្ដែងនឹងការថ្លែងអំណរគុណនិងកោតសរសើរដល់ក្រុមការងារយុវដ្ឋានសហប្រតិបត្តិការអន្តរជាតិអង្គការកម្មសិទ្ធិបញ្ញាពិភពលោកចំពោះកិច្ចខិតខំប្រឹងប្រែងរៀបចំឲ្យមានសិក្ខាសាលានេះឡើងដើម្បីចែករំលែកនៅបទពិសោធន៍ចំណេះដឹងចំណេះធ្វើជូនដល់សិក្ខាសាលាសិក្ខាកាមយើងខ្ញុំក៏សូមលើកទឹកចិត្តឲ្យសិក្ខាកាមទាំងអស់ដែលជាតំណាងរបស់ក្រុមហ៊ុនសហគ្រាសធុនតូចនិងមធ្យមនេះព្យាយាមយកចិត្តទុកដាក់នៅក្នុងដំណើរការសិក្ខាសាលាហើយជាពិសេសអាចផ្ដល់នូវការចែករំលែកបទពិសោធន៍នានាបើមានចម្ងល់អ្វីសូមឲ្យសួរឲ្យបានអស់ដើម្បីឲ្យអស់ចម្ងល់នៅក្នុងការអនុវត្តការពារកម្មសិទ្ធិបញ្ញារបស់យើងជាទីបញ្ចប់ខ្ញុំសូមជូនពរឲ្យដល់លោកជំទាវលោកស្រីទាំងអស់សូមមានសុខភាពល្អសុភមង្គលនិងជោគជ័យសូមអនុញ្ញាតបើកអង្គសិក្ខាសាលាចាប់ពីពេលនេះតទៅសូមអរគុណ
Thank you so much, Her Excellency Ms. Therese Cameron, for the opening remarks. We'll next like to pass the floor to Director Andrew Ong to give us the opening remarks and the background of what we're doing here today. Thank you so much.
Thank you, Rudy, and a pleasant good afternoon, Cambodia. I'm calling in from Switzerland, Geneva, in the headquarters of World Intellectual Property Organization, and we have with us speakers and presenters from different continents. Let me start by saying, Secretary of State, Ms. Therese Cameron, it's our pleasure to have you, and thank you for your kind words. It is truly a luxury for us to be joining Cambodia and helping Cambodia in this endeavor to pivot SMEs into the electronic platform. On behalf of the Director General of the World Intellectual Property Organization, we'd like to welcome everyone and thank everyone for today's presence. Let me say that this is one of the activities that we do in Cambodia in order to address the dialogue gap. We want to have a conversation, and we want to have a conversation with the SMEs directly and in a way that is practical and useful for you. So in the words of the Secretary of State, Ms. Tekka, you need to ask questions, and indeed, we want you to be fully understood and fully engaging with us on this endeavor. This is not the only endeavor we do. This is just a kickoff of the many things we'd like to do with all the participants today. So let us know what you need. Let us know what are the challenges you face in your endeavors, so we can help you in terms of experts, in terms of access to WIPO tools, in terms of a help desk. And we hope that today we have over 50 participants. We can continually have this conversation and increase the number even to 100 or yes. So I will speak slowly. So as I was saying, we hope the participants will increase. The network of SMEs from Cambodia being helped and assisted by the World Intellectual Property Organization will increase, because we want to have this continuing conversation with everyone. And we don't want it to be a one-size-fits-all. So we want everyone to tell us what are their particular challenges, circumstances, needs, and priorities, so we can have expert clinics, particularly for a particular burning question or a particular topic. So today, we will give you a sampler of everything, but then you choose which one interests you most, which one is most important for your business, whether you're in the health business, in the food business, in the IT business, or in the fashion business. So we can help you in that area. We'd like to thank the government of Jamaica for making this assistance. We'd like to thank the Department of IP, of course, His Excellency Vichaya Sun and his team for providing assistance. IP is very territorial. So therefore, we need the local partner, the local IP office, which is DIP in the case of Cambodia, to be part of this endeavor. And they have been very, very cooperative. They have been very useful and helpful. So thank you so much. We also want to thank the permanent mission of Cambodia in Geneva for the United Nations. I know His Excellency Ambassador Kempivit Long is here, and so we are very honored by his presence. And lastly, let me mention that Chair of the Department of International Cooperation of the International Trade Department has been most cooperative, and we have made this possible only because of his participation. So let me thank Chair in person as well. Now, I'd like to end my short remark by saying that in a few months' time, we shall be in person in Cambodia. The Director General shall be in Siem Reap to attend the Economic Ministers meeting. And we hope that from there, we can pivot to Phnom Penh. And personally, I hope to be there and hope to greet everyone and meet everyone in person in the next few months. So towards that end, and on that note, I thank you all for today's participation, and let today be the start of many things to come. Thank you so much. Rudy, back to you.
Thank you so much, Dr. Andrew, for your remarks. And once again, thank you to the Minister of Commerce, Chair, and his team, and Her Honorable Excellency for being here with us. I also like to pass the floor to Ambassador Long to share a few remarks, and as he was very instrumental in putting this together. Ambassador Long, please.
Yes, thank you very much, Rudy. I was not expected to be called to provide any remark, but first, let me pay my respects to Her Excellency Dr. Kamrong, the Secretary of State of the Ministry of Commerce, Andrew, Yemin, Rudy, yourself, all the speakers and participants. I will be very short because I have not prepared. Just want to say that the purpose of the workshops that we are doing is to bring IP closer to the SMEs, because as we all know, IP is not only for how to register and how to protect yourself, but it's also an asset. So this is something that the Director General of WIPO has always made very clear, that his vision is to see that people using IP as an asset, as a driver for inclusive and sustainable economic growth. So this is why we're doing this, to bring IP closer to the people, and to show them, using the expertise from WIPO to show the SME how that we have the Cambodia Trade platform, the e-commerce platform, which we have mobilized or organized a lot of SMEs to participate, and so it was an idea at that time to utilize this advantage that we have, because we already have the SMEs on board. We know who they are. We can easily contact them. So so that is why we decided that, okay, this workshop is a good opportunity to take, you know, to use that advantage and to get all the SMEs here and to learn from the experts and on how to use IPs for their economic benefit. So I'll stop here, and I'd like to thank Excellency Taret Kumrong, who has been instrumental in, you know, supporting you know, all the activities at the Ministry of Commerce, especially on corporations, like you, who has been always been cooperative. You know, most of the time I like to go through him because he's always been the most responsive, especially to my request. To Andrew, who always been supporting, you know, whatever I'm asking from WIPO, and Jamin as well, and yourself, Rudy, for organizing this, and all the speakers and the official from the Ministry of Commerce, especially the SMEs, the SME who are participating. They are the most important people here, and we have to listen to them on what they want and what are expected of us, and what we can do further to support them, because this is why we're doing this, you know, to support the SMEs. It's not that we're doing everything here just for the sake of doing, or for our own advancement or anything. It's always for the SME. So this is for them. Thank you very much.
Thank you so much for your remarks. And I'd just like to remind your mics if you're not speaking, just so this can flow well. But thank you, Ambassador Long, and thank you to all our keynote speakers who have opened the floor. With that being said, I'd like to pass the floor to our first speaker, Mr. Derek Kim, who's based in the US, who's an attorney in the US, and who would open up the first topic by talking about the foundation of introducing us to the universe of IP, one burning question at a time, starting with why to protect my name, why to protect my work and my ideas in a digital environment. So with that being said, I'd like to pass the floor to Mr. Kim.
All right, well, thank you, Rudy. Thank you, everybody from the Cambodian government. It's truly an honor to be here. Am I all set, Rudy? Everyone you can see my slides here, no problem.
All good.
We're good. Okay. Well, hello, everybody. Just real quick, my name is Derek Honey Kim. I am a consultant in WIPO's Asia Pacific Division, where I work with Director Andrew Ong and my colleagues Yemen, Garima, and Rudy. A little bit about myself. I grew up in the United States. I'm currently calling from the United States. I am a New York State licensed attorney, and I love talking about IP. So I'm looking forward to talking a bit about IP with you today. My first presentation is going to be a glimpse into the IP universe. There are many types of intellectual property, and I think it is easy to become overwhelmed. But first, I want to talk about intellectual.
IP ជាទូទៅហើយបន្ទាប់មកនិយាយអំពីលក្ខណៈថា IP នៅកម្ពុជាដែលលោកស្រីគេថាបានចូលរួមនៅក្នុងនេះជាពិសេសគឺថាសហគ្រាសទុនជំនាញឯងដូច្នេះហើយនៅក្នុង IP គឺថាចាប់ដើមដោយដំបូងមកខ្ញុំគិតថាគឺថាវាអាចមានការផន់ច្រឡំណាប្រចាំគឺថានេះគឺថាអ្វីប្រចាំដើមដំបូងណាជាមូលដ្ឋានសំខាន់ខ្ញុំជឿថាលោកទាំងអស់នេះគឺថាមានកំណត់ដែលគេបង្កើតពីតម្លៃបង្កើតតម្លៃបង្កើតការងារដែលបង្កើតលុយចំណូលចំខ្លួនឯងនិងអ្នកដែលជំនួសខ្លួនឯងដូច្នេះតាមរយៈកំណត់នេះតាមរយៈការធ្វើនៅវិរិវត្តដើម្បីកែលម្អ នៅទូនាទីនឹងគេហៅថាជីវភាពនិងសេដ្ឋកិច្ចនៅក្នុងស្រុកដូច្នេះហើយនៅក្នុងកំណត់តែឥឡូវនេះវាគឺជាគេថាសម្បត្តិគេថាកសិបញ្ញា ឬក៏សិទ្ធិបញ្ញានេះឯងដែលយើងជាម្ចាស់
So the idea becomes yours. The idea becomes property when you express it, when you do something with the idea. I think this is very important for many of you because I think it's very easy to get caught up in the technicalities, but this is where all IP starts. Starts with an idea that is then expressed. Oh, and before I get started, I want to do my Jumri. So I wanted to try my Khmer introduction. So I'm so sorry I missed that. Unfortunately, that's all the Khmer I have for now. I will continue to work on it. First, let's talk about patents. Patents, as well as all intellectual property, is the right to exclude. What does that mean? So there are two types of patents, as you see below here. There's a design patent, there's a utility patent. But patents in general, I think it's useful to think of in two ways. One, what do you get? What do you receive from a patent? And number two, what do you give when you get a patent? So let's start with number one. What do you get with a patent? What you receive is the legal right to exclude other people from using or making your invention. It is the right to exclude others. That is what you receive when you register a patent. Now, what do you give? What you give is public disclosure of your information. You make the information about your invention public so that other people can see your invention and then receive other ideas. So I think this is very useful to think of with patents, because patents can be very technical, very scientific. But this is the basics. So let's talk a little bit about design patents and utility patents. We'll start off with design patents. A design patent protects how an invention looks. It's about visual. It's about how something looks. So a very famous, probably the most famous design patent today is the iPhone. Specifically, when you log into your iPhone, there is the exterior, the way the phone looks, but also the way your apps are spread out on your phone. So Apple has a design patent on how an iPhone looks, as well as the Coca-Cola bottle. These are two very famous design patents. So let's talk a little bit about utility patents. Utility patents protects the creation of a new, improved invention. So think of the light bulb, think of GPS navigation systems. Maybe some of you, to get around, you use your phone and use a navigation system. It protects the creation. These are much more technical of some kind of invention. So those are patents. That's a very big picture way of looking at patents. Next, I want to talk about trademarks, because I think these will be very relevant to many of you. A Cambodian specific with trademarks is that trademarks must be visible. I want to say that one more time because that is very important. Specifically to Cambodia, it is that trademarks must be visible. I say this because in other countries, sounds as well as smells can be trademarks. However, that is not the case in Cambodia. So what is a trademark? Well, it can actually be a lot of things. It can be a symbol, it could be a mark, it could be one letter, or maybe a group of letters. However, there's one key part of all trademarks. It is that it distinguishes a source of goods or services. When somebody sees the trademark, they immediately think of the source, where they are getting the beer here or Coco Khmer. They know immediately where they're getting their source of goods or services. That is the basic of trademarks at the most basic level. I want to talk now a little bit about some Cambodian law specifics here, because I think this will be the most helpful to many of you. So this first part, I want everyone to think of as a gateway. It is the entry to be able to register a trademark in Cambodia. I want to make it very clear that these 4 points I have here, they are not all inclusive. There are other points that have to be referred to. However, these four I think are very important. They're kind of the big pieces of trademark registration. So to be able to register your mark in Cambodia, it has to pass these tests. Number one, the mark has to be distinguished from other marks. In other words, you have to look at other registered trademarks and ask the question, is it different? Is it distinguishable from other marks? Is it special in some way? Number two, the mark cannot go against, it cannot be contrary to public order, morality, or good custom. So if there's something about the mark that might make you a little nervous, that you think might offend other people or offend the general public, you probably shouldn't use it as your trademark. Number three, your trademark cannot resemble any official Cambodian state government bearing or flag or emblem. Basically, when somebody looks at your mark, they should think of your business. They should think of your small or medium enterprise. They should not be thinking of the government. It has to be very specific. And finally, and point number four really kind of sums up the other points. It cannot be confusingly similar with other marks. So a good rule for many of you, if you are looking to register a trademark, is be as unique as possible. It shouldn't be like other marks. It shouldn't be like the government. People should think of your business and your business only. So these 4 points, again, they are not all inclusive. It is not everything, but they are the big pieces that you need to know, the big tests that you have to pass to be able to register a trademark. So let's talk a little bit more in depth about registering a trademark. There's really 2 big steps. Number one, you have to file a trademark search application with the Ministry of Commerce, who is joining us here today. So that's the first step. And filling out that trademark search application, you have to provide certain information, such as an example or a specimen of your trademark. How do you want to classify that mark? And if you have registered it before, some basic information you have to include in your trademark search application. So what happens after that is the government is going to look at your application and really ask kind of 2 very big, important questions. Number one, is it distinguishable from other marks? You see that this is a very common theme, a common pattern here with trademarks. And number two, does it violate the Article 4 requirements? Remember what we talked about here, kind of talking about, is it distinguishable? Does it go against public order? Is it confusingly similar? That's the second kind of really big test that they're going to ask. So those are kind of the big pieces here that we're talking about when we register a trademark in Cambodia. So we kind of breeze through all this, and I want to wrap up my first presentation talking about why intellectual property. I think many small to medium-sized enterprises, they ignore intellectual property because it seems very, it seems technical. Oh, I'm so busy. This is something I can worry about later. But intellectual property is so important, not only for our businesses today, but for the countries and the societies that we live in. I think there's 2 ways we can think about intellectual property and why it is so important. Number one, think about the individual. Intellectual property provides legal protection. Again, it provides the right to exclude other people. And as a result of having that legal protection, you receive revenue. You get to make money off of your invention. Think of intellectual property rights as securing what is yours. Remember at the very beginning of this presentation that we talked about, we all have ideas, but we have to express ideas. And once we express it, once we register our trademark or our patent, it becomes ours. We get to make money off of it. And second is the more big picture. What intellectual property does for the societies we live in. Number one, it provides sustainable economic growth. When we look at countries that have developed, such as a country where I am originally from, South Korea, the country's development is always correlated with intangible assets, with intellectual property. And that is because intellectual property, it provides sustainable economic growth for the long term. And that leads to more stable economies, and that leads to the betterment of the societies and the countries that we live in. So always please remember that whenever you talk about intellectual property, that all innovation starts with each and every one of you. And I'm very excited to see that how maybe some of us are going to take the information we learned here today, innovate and create better societies and a better world around us. So that is the end of my my first presentation. So next off, I'm gonna transition here to my next presentation. So 1 second here. Okay. Well, thank you everybody for your attention to my first general presentation. The second one, I want to get a bit more specific. I want to talk about branding benefits in electronic commerce. In other words, what are the benefits of branding my business, my small to medium-sized enterprise on the internet, which is where we do so much of our business today, which is where so much of intellectual property happens. So here we go, we're going to start off. The first thing that we're going to talk about, and this is a very general point, so fundamental to intellectual property lawyers, but to so many of you, and it's that technology always outpaces the law. I'll say that one more time, is that technology is always faster than the law. If technology and the law are racing, technology is always far ahead, and the law is always trying to catch up somehow. So for example, let's talk about trademarks and branding. As you can see here, the top picture is the Coca-Cola advertisement, which in the past was simply just put on a wall somewhere, a billboard. It was just a sign, and that was it. It was very simple. However, as we all know today, branding and advertisements have gone electronic, and the internet has changed so much of how trademark enforcements work, how trademarks are registered. So with trademark law, this leads to two very big questions. It's the question of, one, territory, and number two, sovereignty. Those are kind of really big words. So I want to simplify it a little bit. One, with territory, where is the trademark enforced? If you remember this sign here, with the old Coca-Cola logo, it was very simple where you enforce the trademark. It was just the geographical area where the Coca-Cola sign or Coca-Cola advertisement was placed. However, that's not the case anymore with the internet, because we have to ask, where is the internet? So number one, where is the trademark enforceable? And number two, the question of sovereignty. Who, what person, what government has the right to enforce the trademark when the trademark is used all over online? So these are the two fundamental questions that we need to ask when we're talking about electronic commerce on the internet. So let's do a quick review here. Again, trademarks at a very basic level, this can always stay the same. It distinguishes the source of goods and services. In Cambodia, trademarks must be visible. It's something we see with our eyes. There are many different standards in different countries about how you use a trademark. Trademark use is very, very important to trademark enforceability. One word you will hear very often is actual use. And that means simply that the source of the good or service use the good somehow in commerce. Now, we're going to put a little spin on that because we're talking about electronic commerce. And another quick reminder that in Cambodian law is mark has to be visible, okay, and capable of distinguishing enterprises, goods, or services. So trademarks in electronic commerce, what are the benefits? What are the differences? I think it boils down to these four things. There's a lot of interplay with these four. So one, it establishes your brand identity in a very overcrowded world. The internet is very fast. The internet has no borders. So a trademark in e-commerce establishes yourself in a very crowded field. And by establishing yourself, you can then protect yourself against brand damage. Then the chief benefits, I think, is, as we know online, it is much easier to interact with customers. I think that is a huge benefit of trademarks in electronic commerce. And the big picture benefit of all that is that there are increased business opportunities for all of you. So I want to talk about genuine use. So we talked about actual use. In many different jurisdictions and countries, courts have ruled that genuine use in electronic commerce of a trademark is okay. What does that mean, genuine use? Well, one way of thinking of it is that online, your trademark cannot be idle. It cannot be just sitting on a homepage somewhere. You have to really do something with the trademark online that brings in money, that brings in revenue for you. Once again, this highlights the importance of use in trademark law. It is one thing to create and design your mark or your logo or that becomes your trademark, but you have to actively use it on the internet if you are to have any chance of receiving protection. So ask yourself a very basic question, and we'll come back to this in a little bit. Was my mark actually present in the online market? In other words, did I use my mark online in a way for me to make money and do business? This is a very fundamental way for us to think about how we enforce trademarks and branding in electronic commerce. So let's talk a little bit more about genuine use. Again, it asks the question whether the trademark was actually present in the online market. There are two ways that people kind of determine this. Number one is using actual sales data. It will correlate with how you use your mark. You could say, well, when I use my mark on my website this many times, I made this much money. There is a direct correlation and relation with how I'm using my mark online and with the money I make. Number two is the kind of relationships that you have with your customers. In other words, are you using your mark online to create commercially motivated relationships? That is, are you making relationships that bring in money for your business through using your mark? I hope that many of you are now seeing that this is exactly why you can't just have a mark online idly that just sitting there on a page. You have to use it somehow in a commercially motivated way that brings in revenue. So those are the key points in branding and electronic commerce. Now, the next thing here I'm talking about is brand infringement. Just as trademarks can be infringed in the physical, real world, trademarks can also be infringed in the digital, online, electronic world. So that's what we're going to talk about. So when you register your mark, it is very, very, very important that you continue monitoring your mark. You shouldn't just say, oh, the Ministry of Commerce has registered my mark, so now I'm good. No, you always need to be proactive. You need to always be monitoring your mark. How do I monitor my mark, I ask? I think there's three main ways. Number one is keep track of your country's trademark registry. There's always going to be new trademarks coming out. And I think it's always a good practice as intellectual property conscious people to always keep track or have a general awareness of what marks are being uploaded. Number two is very simple, just an online search using a search engine like Google or Bing or Yahoo. Just search different businesses, see what's coming up. And the final one is probably maybe the most easiest, is just through social media. Look at your competitors. What are the popular names or logos or pictures that are being used for trademarks? always, always, always make sure you are monitoring your trademark. Next year, I want to talk about two kind of standards you can use to ask whether somebody else has infringed my trademark online: customer confusion and harmful reputation. So this goes back to Article 4, which I talked about in my previous presentation about the gateway tests, the standards that a mark must meet to even have a chance at receiving trademark protection. So Cambodian law says, again, it has to be distinguished. It cannot mislead people. When someone looks at the mark, they have to directly think of your small or medium-sized enterprises. It shouldn't mislead them to other companies or the government. And again, it cannot be confusingly similar. So maybe you've registered your trademark, but then you realize that somebody else with a similar business has a similar name or similar logo. That might be confusingly similar, and you might have a potential claim for trademark infringement. Harmful reputation. Ask yourself, does another mark that you have found, does it harm your mark's reputation? In other words, does it make you look bad? Does it make your company look unnecessarily bad in some way? And always remember that the baseline standard for this, going back to Article 4, is that a trademark cannot be contrary to public order, morality, or good custom. So always, always, always be monitoring your mark, even after you've registered it, and ask yourself, are customers being confused, or is your mark's reputation being harmed? Let's wrap up here. Let's finish this presentation here, talk about the branding benefits in e-commerce. These are the three big ones, and again, I think they really work together. Number one is customer retention. In other words, long-term customer relationships. When we use a brand online, especially because there are so many brands online, there's an emotional attraction and pull, because your consumers can now identify your mark in a crowded field. And once they're able to identify your mark, they're more likely to come back to you. And when they're more likely to come back to you, they're less likely to just look at prices. They're going to look at your mark and have an emotional connection and come back. So that is one very important branding benefit. Number two is being able to understand your customers. And that is because online, we're not limited by time and space like in the physical world. Kind of like right now, I'm in the United States, but because of the internet, I can talk to people in Geneva, Switzerland. I can talk to all of you in Cambodia. And very, very much the same way with all of you. Once you register your mark online, you're able to have greater interaction with your customers. And that will always lead to long-term growth. And finally, the big picture, and this is just a underlying assumption, is increased business, greater reach because of the capabilities of the internet. And your customer base is no longer just Cambodia, but it is also the world around us. A very big benefit of the internet is that it is borderless. And even though because the internet has no borders, that can create a lot of problems for intellectual property lawyers like myself. However, for small to medium-sized enterprises like many of you, it has great potential. And I hope that some of the things we talked about here today really show you why registering your trademark and branding in the electronic world that is the internet has so many benefits. So I want to thank everybody so much for your time. I believe we will have a question and answer session tomorrow. So if you have a question or something you'd like to ask, please hold on to it. But thank you so much. It's been such a pleasure talking with all of you. I will now hand it back to my colleague, Rudy. I think I got that right. So thank you so much, and we'll talk again soon.
Thank you so much.
Thank you, Derek, for that presentation. We actually have a question and answer session today for the last 30 minutes. So hang on, Derek. But thank you so much for everybody being here. And I also like to acknowledge the president of the Department of Intellectual Property Cambodia, who are here with us. The next speaker will be Mr. Tori, the Deputy Director of Department of Intellectual Property in Cambodia. His topic is going to be trademark rights in a digital environment. What rights do companies have in the digital environment, and what is meant by protected by law, as Derek mentioned. So with that being said, I'd like to pass the floor to Mr. Tori, and also like to just remind all participants, please keep your mic on mute at all times, just not so as to not disrupt the flow of the presentation. And also for people on their phone who are looking for interpretation, just click on the button more, and you see live interpretation. You choose the language you want, either English or Khmer. So with that being said, please feel free to already start putting questions in the Q&A, in the chat box. But we'll have a live Q&A session where the businesses can speak about, ask questions related to the business in particular. So with that being said, Deputy Director, Mr. Tori, the floor is passing the floor to you.
សូមអរគុណDede ជាបឋមខ្ញុំបានសូមគោរពលោកជំទាវទឹករីកម្រងរដ្ឋលេខាធិការក្រសួងពាណិជ្ជកម្មអាដាមលង្កាវិចិត្រអគ្គរដ្ឋទូតស្ថានបេសកកម្មចិនត្រៃប្រចាំនៅអង្គការកម្មសិទ្ធិបញ្ញាពិភពលោកលោក Andrew Michael Ong នាយកនៃការិយាល័យអាស៊ីប៉ាស៊ីហ្វិកនៃអង្គការកម្មសិទ្ធិបញ្ញាពិភពលោកលោក Jamin Thong មន្ត្រីជាន់ខ្ពស់នៃការិយាល័យអាស៊ីប៉ាស៊ីហ្វិកនៃអង្គការកម្មសិទ្ធិបញ្ញាពិភពលោកហើយក៏សូមជម្រាបសួរហើយឧត្តមលោកស្រីដែលជាសិក្ខាកាមចូលរួមនៅក្នុងវគ្គដ៏មានសារៈសំខាន់នេះគឺថ្ងៃនេះយើងហៅថាយើងមាន topic គឺ training course ទាក់ទិនទៅនឹងការបង្កើនការប្រកួតប្រជែងផ្នែកធុរកិច្ចនិងការរីកចម្រើនតាមរយៈការប្រើប្រាស់វិស័យកម្មសិទ្ធិបញ្ញាអញ្ចឹងថ្ងៃនេះខ្ញុំមានកិត្តិយសដ៏ខ្ពង់ខ្ពស់ដែលត្រូវបានចាត់តាំងហើយនឹងអញ្ជើញឲ្យចូលរួមធ្វើជាវាគ្មិនទាក់ទិននៅវគ្គនេះដែលមានសារៈសំខាន់បាទហើយខ្ញុំបាទឈ្មោះតូរិតអនុប្រធាននាយកដ្ឋានកម្មសិទ្ធិបញ្ញាក្រសួងពាណិជ្ជកម្មនៃព្រះរាជាណាចក្រកម្ពុជាអញ្ចឹងដើម្បីកុំឲ្យខាតពេលខ្ញុំសូមចាប់ផ្ដើមតែម្ដងបាទពេលវេលាមិនជាវែងប្រហែលទេបាទ
Yes, I can hear you.
Okay. វាមានបញ្ហាអ៊ីនធឺណិតវាដាក់ដុបតិចបាទអញ្ចឹងថ្ងៃនេះខ្ញុំមាន6ចំណុចបាទនៅក្នុងមាតិកាទី1គឺការប្រើប្រាស់ម៉ាកនៅក្នុងវិស័យពាណិជ្ជកម្មហើយទី2តើអ្វីទៅជាសិទ្ធិរបស់ពាណិជ្ជសញ្ញាសិទ្ធិម៉ាកសិទ្ធិនៃម៉ាកទី3ទាក់ទិននឹងការការពារពាណិជ្ជសញ្ញានៅក្នុងបរិបទឬក៏បរិស្ថាននៃ digital បាទទី4ទាក់ទិនទៅនឹងការការពារពាណិជ្ជសញ្ញាបាទចំណុចមួយទៀតគឺទាក់ទិននឹង legal framework គឺក្របខ័ណ្ឌច្បាប់ហើយចំណុចចុងក្រោយតើការការពារពាណិជ្ជសញ្ញាហ្នឹងតើយើងគួរទៅរកស្ថាប័នណាដើម្បីយើងធ្វើការការពារក្នុងឋានៈជាម្ចាស់សិទ្ធិបាទចឹងសូមអនុញ្ញាតបន្តទៅ slide បន្ទាប់ បាទអញ្ចឹងអ្វីទៅដែលយើងហៅថាការប្រើប្រាស់ម៉ាកនៅក្នុងវិស័យពាណិជ្ជកម្មយើងបាទសូមពិនិត្យមើលទាំងអស់គ្នានៅខាងក្រោមនេះកាលណាយើងមានគំនិតយើងបង្កើតនៅអ្វីមួយបាទយើងគិតថាយើងនឹងធ្វើធុរកិច្ចអីមួយបាទអញ្ចឹងយើងគិតហើយយើងចាប់ផ្ដើមបង្កើតជាក្រុមហ៊ុនឬបង្កើតជាសហគ្រាសតើមុខរបរអីដែលយើងគួរប្រកបបាទអញ្ចឹងបន្ទាប់មកកាលណាយើងផលិតហើយយើងផលិតចេញជាផលិតផលហើយអញ្ចឹងយើងត្រូវមានពាណិជ្ជសញ្ញាត្រូវមានម៉ាកកាលណាយើងអត់មានម៉ាកយើងមិនដឹងថាតើអ្នកប្រើប្រាស់ឬក៏អ្នកទិញគាត់មិនដឹងថាជ្រើសរើសយ៉ាងម៉េចទេបាទវាចេះលោតអានេះវាមានបញ្ហា slow ទេខ្ញុំមិនដឹងថាលោកស្រីហ្នឹងពេលដែលមានបញ្ហាអ៊ីនធឺណិត slow ហ្នឹងខ្ញុំអត់ដឹងអាចជួយប្រាប់អបបាទអញ្ចឹងកាលណាផលិតផលយើងមានពាណិជ្ជសញ្ញាហើយមានម៉ាកហើយតែយើងត្រូវធ្វើមិនទៀតជំហានបន្ទាប់អញ្ចឹងយើងត្រូវយកម៉ាកសញ្ញាយើងយកមកចុះបញ្ជីបាទពេលដែលយើងធ្វើការចុះបញ្ជីហើយយើងទទួលបានសិទ្ធិស្របច្បាប់ក្នុងការប្រើប្រាស់នឹងហើយយើងនឹងធ្វើការថែទាំគេហៅការគាំពៀយើង maintain វាតែធ្វើម៉េចដើម្បីឲ្យសិទ្ធិនឹងវានៅគង់វង្សបាទអញ្ចឹងយើងត្រូវគាំពៀតាមនយោបាយអីយើងការពារបាទតាមរយៈនៃការចុះបញ្ជីអីចឹងទៅនឹងខ្ញុំនឹងបង្ហាញនៅ slide បន្ទាប់អញ្ចឹងឥឡូវយើងមើលតើសិទ្ធិរបស់ម៉ាកហ្នឹងមានអីខ្លះមានន័យថាសិទ្ធិម្ចាស់សិទ្ធិពេលដែលគាត់បង្កើតគាត់ចុះបញ្ជីហើយនេះតើសិទ្ធិគាត់អាចធ្វើបានខ្លះបាទអញ្ចឹងទី1គឺសិទ្ធិក្នុងការប្រើប្រាស់ម៉ាកទី2សិទ្ធិក្នុងការគាត់អនុញ្ញាតឲ្យទៅអ្នកណាម្នាក់ក្នុងការប្រើប្រាស់ម៉ាកក្រោមការគ្រប់គ្រងរបស់គាត់ឬគាត់អាចមានសិទ្ធិលក់បន្តអាចមានសិទ្ធិផ្ទេរបាទផ្ទេរពីទៅភាគីណាក៏បានដែរអានេះជាសិទ្ធិរបស់គាត់ក្នុងការប្រើប្រាស់ម៉ាកបាទហើយទី3សិទ្ធិក្នុងការចាត់វិធានការស្របច្បាប់ប្រឆាំងទៅនឹងភាគីណាមួយដែលរំលោភបំពានម៉ាកសញ្ញាដែលបានចុះបញ្ជីហើយអាហ្នឹងក៏ជាសិទ្ធិមួយដែរបាទហើយទី4គឺសិទ្ធិអ្វីគឺសិទ្ធិក្នុងការអនុវត្តគាត់អាចដាក់ពាក្យ complaint ដាក់ពាក្យប្តឹងទៅស្ថាប័នគយដើម្បីឲ្យស្ថាប័នគយនឹងរាំងខ្ទប់ទំនិញណាដែលខ្លែងបន្លំម៉ាកគាត់បាទអញ្ចឹងគយលោកខាងអាជ្ញាធរគយគាត់មានឆន្ទៈសិទ្ធិក្នុងកិច្ចការនេះបើសិនជាមានពាក្យបណ្ដឹងហើយគឺគាត់អាចខាត់ទំនិញណាដែលមានការខ្លែងបន្លំម៉ាកបាទខាត់ទុកអញ្ចឹងឥឡូវយើងមើលបាទខ្ញុំសូមពេលបន្តិចដើម្បីខ្ញុំបញ្យល់នៅសិទ្ធិមួយហ្នឹងបាទសិទ្ធិក្នុងការប្រើប្រាស់ម៉ាកហ្នឹងវាមានសិទ្ធិផ្ទាល់មានសិទ្ធិមិនផ្ទាល់បាទមានសិទ្ធិនឹងប្រើឲ្យត្រឹមត្រូវឲ្យដោយការចុះបញ្ជីខ្ញុំនឹងរៀបរាប់នៅ slide បន្ទាប់ឥឡូវយើងមើលសិទ្ធិទី2នេះសិទ្ធិក្នុងការផ្ដល់អាជ្ញាប័ណ្ណទៅភាគីផ្សេងបាទជួនកាលគាត់ដូចថាគាត់មិនធ្វើខ្លួនឯងទេអាចគាត់ប្រគល់សិទ្ធិទៅឲ្យភាគីណាផ្សេងទៅគាត់ផលិតទៅគាត់ធ្វើទៅបាទហើយគាត់អនុញ្ញាតឲ្យគេប្រើប្រាស់ម៉ាកសញ្ញាទៅប៉ុន្តែក្រោមការគ្រប់គ្រងរបស់គាត់មានន័យថាទាំងគុណភាពបាទមានន័យថាទាំងស្តង់ដារជាពិសេសគុណភាពគឺធ្វើម៉េចទៅតាមអ្វីដែលគាត់បានកំណត់នៅក្នុងកិច្ចព្រមព្រៀងរវាងម្ចាស់សិទ្ធិនិងអ្នកទទួលសិទ្ធិបាទហើយឥឡូវខ្ញុំនឹងបញ្យល់លម្អិតនៅ slide បន្ទាប់ ខ្ញុំអាចសូមអនុញ្ញាតមកទៅ slide បន្ទាប់ឥឡូវយើងមើលអានេះជាអ្វីដែលខ្ញុំសង្ខេបបាញ់មិញទី1យើងមើលអាកណ្ដាលចំណុចកណ្ដាលគេហៅសិទ្ធនៃម៉ាកបាទសិទ្ធនៃម៉ាកទី1គឺពេលដែលគាត់ចុះបញ្ជីហើយហ្នឹងគាត់មានសិទ្ធិប្រើប្រាស់បាទចំណុចមួយទៀតគាត់មានសិទ្ធិធ្វើអាជ្ញាប័ត្រមានន័យថាគាត់អនុញ្ញាតឲ្យភាគីណាមួយដើម្បីប្រើប្រាស់ម៉ាកនេះដូចជាផលិតឲ្យគេផលិតទៅគាត់គ្រប់គ្រងពីលើទៅហ្នឹងហើយគុណភាពឲ្យតាមស្តង់ដាររបស់គាត់ជាម្ចាស់សិទ្ធិបាទអញ្ចឹងបន្ទាប់មកចំណុចនេះគឺត្រូវធ្វើម៉េចបាទចំណុចពណ៌ខៀវនេះគឺ action គាត់មានសិទ្ធិចាត់វិធានការស្របតាមច្បាប់ក្នុងករណីដែលគាត់រកឃើញថាឥឡូវនេះគឺមានភាគីណាមួយមានក្រុមហ៊ុនណាមួយដែលធ្វើការរំលោភម៉ាករបស់គាត់បាទរំលោភម៉ាកគាត់មានសិទ្ធិប្តឹងទៅអាជ្ញាធរមានសមត្ថកិច្ចស្ថាប័នពាក់ព័ន្ធបាទឲ្យចាត់វិធានការទៅតាមច្បាប់ហើយចំណុចក្រហមចំណុចចុងក្រោយនេះគឺ prevent importation គឺដូចខ្ញុំបានរៀបរាប់ចឹងគាត់មានសិទ្ធិប្តឹងទៅអាជ្ញាធរគយដើម្បីឲ្យខត់ទុកបាទចាប់ខត់ទុកនៅទំនិញដែលសង្ស័យថាមានម៉ាកខ្លែងបន្លំបាទអញ្ចឹងសូមអនុញ្ញាតទៅ slide បន្ទាប់បាទឥឡូវយើងមើលtrademark protection in digital environment ការការពារម៉ាកនៅក្នុងបរិបទ digital នៅក្នុងបរិយាកាស digital យើងដឹងសពថ្ងៃហ្នឹងគឺវាមានបញ្ហារីកចម្រើនខ្លាំងមែនទែនយើងមាន smartphone មាន smart watch មានរបស់របរប្រើប្រាស់ហ្នឹងគឺទំនើបមែនទែនបាទអញ្ចឹងឥឡូវយើងមើលទាំងអស់គ្នាថាតើអ្វីទៅដែលជាទ្រព្យសម្បត្តិ digital ដែលហៅថាទ្រព្យសម្បត្តិ digital ហ្នឹងគឺជាព័ត៌មានដែលត្រូវបានបង្កើតឡើងឬក៏យើងហៅថា electronic record បាទគឺជាព័ត៌មានដែលបានបង្កើតឡើងហ្នឹងហើយវាមាននៅក្នុងទម្រង់ជា digital បាទឬក៏យើងហៅថា electronic storage device ឬក៏យើងច្រើនហៅថា online បាទអាហ្នឹងហើយគឺជាទ្រព្យសម្បត្តិ digital ហើយយើងមើលរួមមានអីខ្លះដូចជា audio ដូចជាសំឡេងដូចជាភាពយន្តដូចជាគេហទំព័រដូចជា mobile app បាទដូចជា social media ដូចជា page អីហ្នឹងដូចជា Facebook អីក៏តាម Instagram អីចឹងទៅបាទ email អីអាហ្នឹងក៏ចាត់ទុកទៅក្នុងទ្រព្យសម្បត្តិគេហៅថា digital property ហ្នឹងដែរបាទទី2បាទចំណុចមួយនេះទៀតគឺតាក់ទិនទៅនឹងគេហៅថាការរំលោភបំពានម៉ាកនិងអ៊ីនធឺណិតតើវាមានទំនាក់ទំនងយ៉ាងម៉េចយើងមើលបច្ចុប្បន្នដូចខ្ញុំបានលើកបាញ់មិញគឺជាពេលវេលាមួយគេហៅថាជាបរិបទជាពេលដែលយើងមានភាពរីកចម្រើនខ្លាំងនៅលើវិស័យ digital ហ្នឹងគេហៅយុគសម័យ digital ហ្នឹងគឺទី1ទោះបីជាវារីកចម្រើនយើងហៅថាវារីកចម្រើនអញ្ចឹងវានាំឲ្យមានភាពជោគជ័យច្រើនបាទហើយក៏មានភាពគ្រោះថ្នាក់ដែរទៅដល់អ្នកបង្កើតទៅដល់តតកទៅដល់អ្នកប្រើប្រាស់បាទដោយសារថាឧទាហរណ៍ថាឥឡូវនៅតាមអនឡាញប្រព័ន្ធអនឡាញវាមានការរីកចម្រើនវាផុសគឺថាយើងផុសយើងអីយើងចង់បានរូបភាពយើងចង់បានព័ត៌មានយើងកាន់តែចុចទៅគឺវាលោតឲ្យតែម្ដងបាទហើយយើងកុំភ្លេចថាអ្វីដែលអ្នកបង្កើតអ្នកប្រើប្រាស់នឹងគឺមានភាពជោគជ័យមានភាពងាយស្រួលក៏វាបង្កភាពងាយស្រួលទៅដល់អ្នកដែលចាំគេហៅថាចាំលួចបាទចាំលួចចម្លងចាំកូពីចម្លងអញ្ចឹងហើយអ្នកដែលមានបំណងគេហៅថា bad faith ហ្នឹងគឺចាំមកលួចចម្លងហ្នឹងមិនមែនអន់ប្រមាណខ្ញុំជឿថា mình on để bà chạy vị trí cứ bộ nâng cứ chạy sẵn chẳng ảnh nâng có dân complete này tận tâm nâng phiếp chụp chế này digital tá có bằng có phiếp nghi số từ đó nè tại là cái hàng hacker và nè lui như vậy trọng nhưng mới nơi tam internet và con internet cao một lúc một tiền nó cứ việc xưng cao lang cột lại nơi lừa bị phục lộ việc cao lang trai mình tên hay lươn này và lươn này bây giờ bị mình tray ăn watch bắp mình tray sát ban bẹ con ấy nè đã ăn watch tụi mình tục hàng ca bằng crab ca nó watch bắp thử to tái cứ miếng chạy phải chạy chiến từ khang này u này và việc cả láng cứ sân được cột lại và hay cá pra căn là can láng nhưng thử kịch hà cá pra tam online căn là can láng vì một ngày từ một ngày cứ việc căn là miên ca và ba lùm ba còn cá pía brand bóc ở phía tây bằng mùi bóc crom hôn và bóc cái hai thà ta có bỏ một chặt dịch để căn là miên ca làm bạc bạn chân phim xong bạn nháp to từ slide top tiếp 7 nhưng mưa thật ta thường bắt đầu bây ca pía trọc sầm bát digital này bạn tí mùi nhưng cực mới tí muối cái hai tha dương thử miền tam from hôn tam hạ kia ấy dương cua miền cả multiple administrator nè đại là group gồm những ở tràn tới và ở tràn thì họ tha nông cạn này đại miền bọc lực mà nè pi nè ấy quạt trả tranh pi from hôn pi hạ kia dương miền nè còn to bên phim đợt đó và những ai một group gồm nơi thọp sản bát digital như bạn và hay TP dương đăng group này hay password lấy sầm ngắt ấy dương thử tại rẽ xa tốc sơ tốc nơi cả lại để miền số bát hiệp và hay password nó cũng đặt clay với tạo quen như chẳng tới và số bát hiệp tạo việc quen hay xa bắt đầu và nó có chỉ chủng nó để dương ai ca bị bàn này và hay tiếp bấy cứ anh nhá ao nhà pra nó cứ quạt ai châu bàn con miền xe châu nó cứ cầm oi oi châu tập này na đây là ai châu bạn và tập này na để ai châu bạn này na để mình ai châu bác từ của bạn mình của hai bờ sân kia cái hai tha và phết đô mình nêm ấy nơi phải chăm cầm hôn sạc kia ấy bờ trong ở đặc biệt sana sông cho mình chi là mấy ca kia mình của đại chia bậc quốc tế và mình của đại chia individual tế của đại chia cái hai thằng không niêm chia cầm hồn và không niêm chia cầm hồn hai đấy bàn chân ở tí họ thả lớn không cả đấy đây là miền ở Pành Ha miền Việt thì cả láng chân cái thời ca ai xa control cái thời ca portang chân bởi dương về để dương prao cho mua cầm hồn xe hay là bây dương trong chi mà cha domain name mà cha brand mà cha trade name đứng mình men chỉ cầm hồn cho một cầm hồn nhưng đã chỉ bảo cô những Việt Nam của bà trong mình tây này tụi mình tập hàng càng nhiều chủng mua đọc sai mua hàng bị biến đến quát thời ca tìm tọt mới hay việc càng ai những cho việc chỉ bảo cô mình để ai cái sáng của mình chặt về hạ đôi chân mình chặt xì cái này và hay chúng nó cũng biết mình cua xe password từ nè đây mình sẵn khăn nè đây là thời gian xé chậm xé và ai dùng nó trong coi nó cứ sẵn khăn này và sẵn khăn nó cứ ca nam yên Pành Ha ấy để dương cần một tờ phong sai bẹ bón nâng ca cái lùi châu lùi ấy nó cứ claim và lom bẹ bón nâng ca lốp ấy đó nhưng ai từ bắc xa cho môi nâng cài lại cầm sập nhà để giúp than cầm sập nhà đây là sọc thái miền từกระทรวงสำคัญทั้งเมียนกระทรวงเป็นกิจกรรมเมียนกระทรวงวัปทวิจิตรศิลปะเมียนในกระทรวงอุตสาหกรรมใจจีนวิทยาวัฒน์จะตามป่ายืนtừ ភាសាទៅឬក៏យើងអាចទៅពិគ្រោះយោបល់ជាមួយនឹង law firm បាទជាមួយនឹងក្រុមហ៊ុនច្បាប់ដែលគេមានជំនាញខាងកម្មសិទ្ធិបញ្ញាយើងពិគ្រោះទៅគួរធ្វើម៉េចដើម្បីការពារទ្រព្យសម្បត្តិ digital ដែលជាផ្នែកមួយនៃកម្មសិទ្ធិបញ្ញាបានបាទឥឡូវយើងសូមមើលបន្តទៀតតើមានអីទៀតឥឡូវយើងមើលមិញយើងនិយាយពីការការពារម៉ាកនៅក្នុងបរិបទនៅក្នុងបរិស្ថានdigital ឥឡូវយើងមើលការការពារម៉ាកជាទូទៅបាទអញ្ចឹងចំណុចទី1នេះគឺកាលណាយើងបង្កើតបានម៉ាកសញ្ញាហើយយើងកុំភ្លេចយើងគួរតែដាក់ពាក្យសារសុំចុះបញ្ជីនៅក្រសួងពាណិជ្ជកម្មនៅនាយកដ្ឋានកម្មសិទ្ធិបញ្ញាហើយទោះបីជាការចុះបញ្ជីម៉ាកមិនមែនជាការបង្ខិតបង្ខំដូចជាការស្នើសុំចុះបញ្ជីដើម្បីបើកក្រុមហ៊ុនប្រកបអាជីវកម្មក៏ដោយប៉ុន្តែសហគ្រាសក្រុមហ៊ុនសហគ្រាសឬក៏ individual ឬក៏រូបវន្តបុគ្គលក្តីនីតិបុគ្គលក្តីហ្នឹងគឺគួរតែដាក់ពាក្យសារសុំចុះបញ្ជីម៉ាករបស់ខ្លួនទៅនៅពេលដែលយើងបង្កើតបានដើម្បីជៀសវាងហានិភ័យក្នុងការលួចចម្លងបាទអញ្ចឹងពេលដែលយើងចុះបញ្ជីហើយយើងទទួលបានវិញ្ញាបនបត្រម៉ាកយើងអាចធ្វើទុតិយតាបានយើងអាចមានន័យថាយើងអាចស្នើសុំចម្លងត្រឹមត្រូវតាមច្បាប់ដើមយើងអាចធ្វើ certify true copy បានបាទអានេះយើងអាចមកធ្វើនៅនាយកដ្ឋានកម្មសិទ្ធិបញ្ញាក្រសួងពាណិជ្ជកម្មបាទអានេះទី1ណាទី2លោកអ្នកប្អូនសូមដូចជាឮសំឡេងក្រៅមកបាទសូមជួយបិទផងបាទអញ្ចឹងអនុញ្ញាតបន្តទៀតយើងមើលចំណុចទី2ចំណុចទី2តេតិននឹងការរក្សាសិទ្ធិបាទគំពីមានន័យថាអ្វីដែលយើងមានហើយគឺនៅពេលដែលយើងចុះបញ្ជីហើយយើងត្រូវទទួលបានសិទ្ធិផ្ដាច់មុខក្នុងការប្រើប្រាស់ម៉ាកនឹងហើយតើធ្វើម៉េចដើម្បីឲ្យសិទ្ធិយើងនឹងវាថិតថេរបាទវាយូរវែងបានគឺចំណុចទី2នឹងត្រូវតែមានការគំពីគឺការថែរក្សានឹងឯងបាទយើងមិនវាមិនខុសពីដើមឈើមួយដើមទេដែលយើងខំដាំហើយហ្នឹងគឺវាដុះហើយយើងត្រូវថែទាំវាដាក់ជីស្រោចទឹកអីចឹងទៅបាទអញ្ចឹងហើយការគំពីហ្នឹងវាមានអីខ្លះវាមានវាតេតិននឹងការប្រើប្រាស់ហ្នឹងឯងសំខាន់ការប្រើប្រាស់មានន័យថាម៉ាកតើកាលណាចុះបញ្ជីហើយបើយើងមិនប្រើវាអាចឈានទៅដល់ការលុបចេញពីបញ្ជីវិញបាទក្នុងរយៈពេល5ឆ្នាំអានេះយោងទៅតាមច្បាប់មាត្រាទី15នៃច្បាប់ម៉ាករបស់កម្ពុជាបាទក្នុងរយៈពេល5ឆ្នាំក្នុងករណីមិនប្រើវាអាចឈានទៅដល់ការលុបចេញពីបញ្ជីវិញបាទអញ្ចឹងវាទាមទារឲ្យមានការប្រើប្រាស់ហើយបើសិនជាយើងប្រើនឹងវាធ្វើឲ្យម៉ាកយើងកាន់តែមានភាពខ្លាំងបាទកាលណាម៉ាកយើងកាន់តែមានភាពខ្លាំងគឺមានន័យថាគេកាន់តែស្គាល់ហើយបើយើងម៉ាកយើងមានភាពខ្លាំងយើងទទួលបានការការពារក៏ខ្លាំងដែរបាទក៏ខ្លាំងដែរបាទអាហ្នឹងគឺចំណុចល្អបំផុតគឺចុះបញ្ជីហើយយើងកុំជីសេះលេងដៃយើងត្រូវប្រើប្រាស់វាណាវាមិនខុសពីទ្រព្យសម្បត្តិយើងមានប្រចាំហើយដូចជាឧបករណ៍កសិកម្មអីយើងមើលគល់អានោះអីបើយើងអត់ប្រើគឺវាអាចវាលែងមុតលែងអីដូចកប៉ិតបថៅអីចឹងវាមិនខុសពីការងារនឹងប្រមាណទេទ្រព្យសម្បត្តិនឹងប្រមាណទេបាទដូចយើងមានដីចឹងយើងមិនអាស្រ័យផលមានអីធ្វើរបងធ្វើអីក៏វាពិបាកដែរណាយើងត្រូវចុះបញ្ជីធ្វើប្លង់ធ្វើអីអញ្ចឹងម៉ាកសញ្ញាក៏អញ្ចឹងដែរម៉ាកសញ្ញាយើងត្រូវទី1យើងចុះបញ្ជីណាដូចយើងធ្វើប្លង់ដីទី2យើងត្រូវប្រើប្រាស់វាបាទហើយប្រើប្រាស់ហ្នឹងគឺប្រើប្រាស់វាមានច្រើនយ៉ាងទៅទៀតទី1ដូចខ្ញុំបាននិយាយទូទៅមកឥឡូវខ្ញុំសូមលម្អិតតិចប្រើប្រាស់វាមានចែកចេញជាគេហៅប្រើប្រាស់ផ្ទាល់ឬប្រើប្រាស់មិនផ្ទាល់ប្រើប្រាស់ផ្ទាល់គឺប្រើខ្លួនឯងម្ចាស់សិទ្ធិគឺគាត់ប្រើខ្លួនឯងតែម្ដង គាត់ផលិតខ្លួនឯងគាត់ធ្វើចរាចរណ៍ទំនិញខ្លួនឯងទៅហើយមួយទៀតគឺការប្រើប្រាស់មិនផ្ទាល់ទៅខ្ញុំនិយាយគឺសិទ្ធិគាត់គាត់អាចធ្វើ franchise ឲ្យភាគីណាមួយទៅបាទយើងប្រគល់សិទ្ធិទៅឲ្យភាគីណាមួយទៅចុះកិច្ចកុងត្រាមួយទៀតឲ្យគេធ្វើទៅផលិតទៅបាទហើយគាត់គណចាំយកថវិកាយកផលចំណេញទៅបាទហើយចាំតែមើលគុណភាពដើម្បីកុំឲ្យវាអាលុំគេហៅថា brand ហ្នឹងបាទម៉ាកហ្នឹងកាលណាយើងត្រួតពិនិត្យគុណភាពអត់បានអញ្ចឹងវាឈានទៅដល់ការបាត់បង់អាហ្នឹងគឺសំខាន់ណាស់បាទអញ្ចឹងម្ចាស់សិទ្ធិគាត់ត្រូវតែមើលគ្រប់គ្រងគឺគ្រប់ពេលតែម្ដងតាក់ទិនទៅនឹងគុណភាពបាទហើយមួយទៀតគឺការប្រើប្រាស់មួយទៀតហ្នឹងគេហៅថា use in the public ប្រើប្រាស់ហ្នឹងមិនមែនតែប្រើល្មមទេប្រើរបៀបជាសាធារណៈទ្រង់ទ្រាយសាធារណៈមិនមែនប្រើតែមួយកន្លែងអីចឹងណាបាទហើយមួយទៀតតាក់ទិននឹងការប្រើមួយទៀតគឺប្រើដោយការចុះបញ្ជីឧទាហរណ៍ថាគាត់ស្នើសុំចុះបញ្ជីឧទាហរណ៍ថាឥឡូវហ្នឹងម៉ាកគាត់មាន XYZ អីចឹងទៅបាទដល់ពេលគាត់ប្រើប្រាស់គាត់មិនមែនប្រើតែ XYZ ទេគាត់ថែមអី B អីមួយទៀតចឹងទៅឬគាត់ថែមចង់និយាយថាអ្វីឲ្យវាផ្សេងក្រៅពីអាម៉ាកដែលគាត់ស្នើសុំចុះបញ្ជីហ្នឹងណាអញ្ចឹងអាហ្នឹងមិនត្រូវប្រើអញ្ចឹងទេឲ្យដូចអ្វីដែលមានបិទនៅលើវិញ្ញាបនបត្រចុះបញ្ជីម៉ាកហ្នឹងបាទចុះហេតុអីបានមកឲ្យប្រើគាត់ថាថែមតិចតួចវាកាលណាយើងប្រើមិនដូចការចុះបញ្ជីទេវាទីមួយវាអាចឈានទៅដល់គេហៅថាមានហានិភ័យមួយគឺឈានទៅដល់វិវាទមានចំនួនឧទាហរណ៍ថាគាត់ថែមរូបភាពឬក៏ថែមពណ៌ថែមពាក្យពេចន៍អីនៅលើម៉ាកដែលគាត់បានចុះបញ្ជីហើយថែមទៅវាម៉ាកដែលគាត់ថែមហើយនោះវាទៅប៉ះជាមួយនឹងភាគីផ្សេងទៅដូរជាមួយភាគីផ្សេងឬក៏ទៅប្រហាក់ប្រហែលច្រឡំរបស់គេអាហ្នឹងគឺគេប្តឹងបាទអាហ្នឹងគេប្តឹងហើយតែប្តឹងមិនត្រូវគ្នាយើងដឹងហើយវាអាចឈានទៅដល់ការលុបការអីចឹងទៅបាទអាហ្នឹងក៏ជាចំណុចមួយលំបាកដែរហើយមួយទៀតយើងដឹងថាការប្រើប្រាស់ហ្នឹងគឺជាយើងហៅថា process of advertising good បាទដំណើរការនៃការផ្សព្វផ្សាយពាណិជ្ជកម្មបាទអាហ្នឹងក៏ជាការប្រើប្រាស់មួយដែរបាទហើយមួយទៀតគេហៅថា genuine use អាហ្នឹងមានន័យថាប្រើប្រាស់ហ្នឹងប្រើឲ្យវាត្រឹមត្រូវវាប្រហាក់ប្រហែលទៅនឹងការប្រើប្រាស់ដូចចុះបញ្ជីដែរគណៈថាវាប្រើហ្នឹងដូចខ្ញុំនិយាយមិញអញ្ចឹងគឺប្រើមិនមែនប្រើតែនៅក្នុង mini mart មួយណាប្រើនៅក្នុងមួយកន្លែងមួយអញ្ចឹងវាផ្សព្វផ្សាយនេះវាអត់ត្រឹមត្រូវទេបាទហើយចំណុចចុងក្រោយគេហៅថា proper use ការប្រើប្រាស់ហ្នឹងឲ្យសមស្របយ៉ាងម៉េចឲ្យត្រឹមត្រូវឬសមស្របឧទាហរណ៍ខ្ញុំលើកឧទាហរណ៍គឺមិនថាគេមិនថាខ្ញុំនេះគឺភាគច្រើនវាប្រើទៅវាប្រើទៅហាក់ដូចជាវាមិនសូវត្រូវឧទាហរណ៍ថាឥឡូវខ្ញុំចង់ញ៉ាំឧទាហរណ៍ថាខ្ញុំចង់ញ៉ាំទឹកក្រូចហើយធម្មតាផលិតផលទឹកក្រូចវាត្រូវមានម៉ាកទឹកក្រូចម៉ាកនេះម៉ាកនោះអញ្ចឹងណាឥឡូវលើកឧទាហរណ៍ទឹកក្រូចវាមានម៉ាក Fanta វាមានម៉ាក Coca-Cola មានអីផ្សេងទៀតចឹងទៅហើយឧទាហរណ៍ថាបើយើងចង់ទៅផ្សារអញ្ចឹងឧទាហរណ៍ថាទៅផ្សារខ្ញុំចង់ទៅ Lucky ឬក៏ទៅ OSA ឬក៏ទៅ Olympic អីចឹងណាបាទអញ្ចឹងអាការប្រើប្រាស់អស់ហ្នឹងយើងគិតថាវាស្រួលនិយាយស្រួលហាត់ប៉ុន្តែការប្រើប្រាស់ហ្នឹងវាអត់ proper ទេគេហៅថាវាអត់សមស្របទេវាមិនត្រឹមត្រូវទេហេតុអីបានអញ្ចឹងវាមិនត្រឹមត្រូវសម្រាប់ខ្លាំងជាងគេនេះគឺចំពោះម្ចាស់សិទ្ធិនឹងឯងចំពោះម្ចាស់ម៉ាកនឹងឧទាហរណ៍ថាឥឡូវឧបមាថាខ្ញុំទៅ Lucky ឬក៏ទៅ OSA យើងដឹងណាអាហ្នឹងសម្រាប់តែអ្នកដែល understood អ្នកដែលយល់ដឹងថាអូទៅ OSA គឺផ្សារ OSA ទៅ Lucky គឺផ្សារ Lucky ប៉ុន្តែដល់ពេលយូរទៅអា OSA និងអា Lucky ហ្នឹង lucky ហ្នឹងវាคล้ายវាមិនមែនទៅជាម៉ាកវាទៅជាគេហៅវាទៅជាផ្សារសម្រាប់អាដាមលោកស្រីដែលជាពលរដ្ឋកម្ពុជាហ្នឹងប្រហែលជាធ្លាប់ឮដូចជាយើងច្រើននិយាយថាទិញលីអូអញ្ចឹងបាទហ្នឹងជាក់ស្ដែងលើកតាមពិតលីអូហ្នឹងជាម៉ាកទេជាម៉ាករបស់ខោបាទខោ slip ខោអីហ្នឹងណាដល់មិនមែនថាទៅទិញខោតំណប់លីអូណាថាទិញលីអូយូរអាលីអូនោះវាទៅជាវាមិនមែនជាម៉ាកវាទៅជាខោដល់ទៅជាខោយូរទៅវាคล้ายទៅជាគេហៅថា generic term វាបច្ចេកទេសនៅក្នុងការត្រួតពិនិត្យម៉ាកហ្នឹងណាបាទវាទៅជា generic ទៅ generic តែកាលណា generic ហើយមិនទទួលបានការការពារទេបាទដល់យូរម៉ាកហ្នឹងវាសាបវាទៅជារបស់មួយទៅទូទៅតែម្ដងអាហ្នឹងឯងដែលម្ចាស់សិទ្ធិគួរយកចិត្តទុកដាក់អញ្ចឹងក្នុងឋានៈជាម្ចាស់សិទ្ធិទៅមានក្រុមមានធីមដើម្បីធ្វើម៉េចយុទ្ធនាការបញ្យលអ្នកប្រើប្រាស់ព្រោះអ្នកប្រើប្រាស់ដូចខ្ញុំនិយាយអញ្ចឹងមិនថាគេមិនចូលចិនជាអាណាខ្លីបាទខ្លីអញ្ចឹងមិនគួរប្រើទេមានន័យថាអញ្ចេះមានន័យថាកុំប្រើជាណោមជានាមត្រូវប្រើជាគុណនាមជា adjective ឧទាហរណ៍ថាទៅផ្សារ I go to ផ្សារអូស័យឬក៏ I go to lucky market ចឹងទៅបាទអញ្ចឹងយើងកុំប្រើថាជាណោនយើងប្រើជាអូស័យយើងប្រើជាគុណនាមដើម្បីបំពេញន័យឲ្យផ្សារពេញបាទនិយាយអញ្ចឹងព្យាយាមបញ្យល់អញ្ចឹងម៉ាកសញ្ញាយើងនឹងវាមិនបាត់បង់ទេវាមិនคล้ายទៅជា generic term ទេបាទអានឹងខ្ញុំសូមប៉ុណ្ណឹងហើយឈានទៅដល់ម៉ោងហើយបាទអញ្ចឹងចំណុចមួយទៀតដើម្បីរក្សាបាននូវសិទ្ធិរបស់យើងសិទ្ធិរបស់ម្ចាស់សិទ្ធិហ្នឹងគឺត្រូវបន្តបាទម៉ាកដែលចុះបញ្ជីហើយហ្នឹងត្រូវបន្ត5ឆ្នាំគេតម្រូវច្បាប់តម្រូវឲ្យមកដាក់ពាក្យបន្តគេហៅប្រតិវេទយើងហៅថាអាពីដវិតបាទហើយរយៈពេល10ឆ្នាំគឺត្រូវចុះបញ្ជីសារឡើងវិញបាទហើយទី3ដើម្បីទទួលបានការការពារសិទ្ធិនឹងយូរអង្វែងបាទអញ្ចឹងយើងត្រូវមានគេហៅថា enforce right នឹងសិទ្ធិនឹងត្រូវ enforce វាត្រូវពង្រឹងបាទត្រូវពង្រឹងយ៉ាងម៉េចទី1យើងគេហៅថា active monitoring យើងគ្រប់គ្រងជាប្រចាំតែម្ដងបាទគ្រប់គ្រងយើងឃ្លាំមើលតើមានអ្នកណាចម្លងរបស់យើងមានក្រុមការងារបាទហើយទី2យើងត្រូវការពារត្រូវរារាំងឬរាំងខ្ទប់ការប្រើប្រាស់ដែលគ្មានការអនុញ្ញាតបាទដែលគ្មានការអនុញ្ញាតហើយចំណុចមួយទៀតដើម្បីការពារបានយ៉ាងម៉េចបើសិនជាដឹងភាគីណាធ្វើការក្លែងបន្លំម៉ាកយើងត្រូវយើងអាចធ្វើលិខិតទៅពមៀនឬក៏ទៅប្រាប់ថាឥឡូវនេះវាជន់វាប៉ះសិទ្ធិរបស់យើងហើយសូមឲ្យបញ្ឈប់បាទហ្នឹងក៏ជាវិធីមួយដែរដើម្បីការពារបានបាទហើយមួយទៀតយើងអាចដោះស្រាយបញ្ហាហ្នឹងវិវាទហ្នឹងបាទអាចដោះស្រាយតាមវិធីសាស្ត្ររដ្ឋបាលតាមនីតិវិធីរដ្ឋបាលហ្នឹងដែលក្រសួងពាណិជ្ជកម្មនាយកដ្ឋានកម្មសិទ្ធិបញ្ញាហ្នឹងតែងតែយកមកអនុវត្តគឺបានជោគជ័យច្រើនបាទហើយមួយទៀតអាស្រ័យទៅលើម្ចាស់សិទ្ធិឬក៏ភាគីពាក់ព័ន្ធអាចដាក់ពាក្យប្តឹងទៅតុលាការដើម្បីដោះស្រាយបញ្ហានេះក៏បានដែរបាទអញ្ចឹងជាសិទ្ធិរបស់ភាគីពាក់ព័ន្ធជាពិសេសម្ចាស់សិទ្ធិបាទហើយអានេះខ្ញុំសង្ខេបអ្វីដែលខ្ញុំបាននិយាយមិញគឺចំណុចពណ៌ខៀវគឺការការពារម៉ាកទី1ត្រូវចុះបញ្ជីទី2ត្រូវមានការគាំពៀទី3ត្រូវពង្រឹងបាទអញ្ចឹងឥឡូវយើងមើលក្របខ័ណ្ឌច្បាប់តើយើងមានច្បាប់អីដើម្បីយកមកអនុវត្តយកមកគាំពៀដើម្បីធ្វើជាមូលដ្ឋានទី1យើងមានច្បាប់គេហៅថាច្បាប់ស្តីពីម៉ាកពាណិជ្ជនាមនិងអំពើនៃការប្រកួតប្រជែងមិនស្មោះត្រង់បាទយើងមានច្បាប់យើងមានច្បាប់ស្តីពី geographical indication បាទយើងមានច្បាប់ trade secret undisclosed information ប៉ុន្តែ នៅពង្រៀងឡើយទេយើងកំពុងតែដដៃដជើងដើម្បីពន្លឿនច្បាប់នឹងព្រោះបញ្ហា trade secret ហ្នឹងក៏វាមានសារៈសំខាន់ខ្លាំងណាស់ដែរបាទហើយទី4យើងមានច្បាប់ស្ដីពីការគ្រប់គ្រងបាទគេហៅ cyber crime law បាទច្បាប់ហ្នឹងគឺជាការមួយជាច្បាប់សំខាន់មួយដែរដែលស្ថិតនៅក្រោមការគ្រប់គ្រងរបស់ក្រសួងមហាផ្ទៃបាទច្បាប់ដើម្បីប្រឆាំងទៅនឹងបទល្មើសទៅតាមប្រព័ន្ធអ៊ីនធឺណិតទៅតាមកុំព្យូទ័រជាដើមហ្នឹងបាទហើយយើងក៏មានច្បាប់ e-commerce បាទយើងដឹងឲ្យថ្មីនេះគឺនៅក្រសួងពាណិជ្ជកម្មហ្នឹងគឺតម្រូវឲ្យគ្រប់ក្រុមហ៊ុនសហគ្រាសទាំងអស់ហ្នឹងដែលធ្វើការគេហៅថាធ្វើអាជីវកម្មទៅតាមប្រព័ន្ធអនឡាញតម្រូវឲ្យបញ្ចុះបញ្ជីបាទឲ្យបញ្ចុះបញ្ជីទៅតាមលក្ខខណ្ឌដែលក្រសួងបានតម្រូវបាទបាទហើយតើនៅទីណាតើម៉ាកសញ្ញាហ្នឹងត្រូវបានការពារនៅទីណាបាទឥឡូវយើងមើលស្ថាប័នពាក់ព័ន្ធទី1នាយកដ្ឋានកម្មសិទ្ធិបញ្ញារបស់ក្រសួងពាណិជ្ជកម្មយើងមើលគេហៅថាគណៈកម្មការប្រយុទ្ធប្រឆាំងនឹងទំនិញคล้ายបាទរបស់ក្រសួងមហាផ្ទៃទី3យើងមានអគ្គនាយកដ្ឋានកិច្ចការពារអ្នកប្រើប្រាស់និងបង្ក្រាបទំនិញថ្លែងបន្លំរបស់ក្រសួងពាណិជ្ជកម្មដែរហើយយើងក៏មានGeneral Department តាក់ទិននឹងស្ថាប័នគយអគ្គនាយកដ្ឋានគយនិងរដ្ឋកទី4ហ្នឹងគឺពាក់ព័ន្ធទៅនឹងការខាត់ទំនិញដែលនាំចូលថ្លែងបន្លំម៉ាកគយដូចខ្ញុំបានរៀបរាប់បាញ់មិញបាទហើយទី5យើងមាននាយកដ្ឋានប៉ូលីសសេដ្ឋកិច្ចបាទប្រឆាំងបទល្មើសសេដ្ឋកិច្ចយើងទី6យើងក៏មានមជ្ឈមណ្ឌលដោះស្រាយចំនួនគេហៅថា National Commercial Arbitration បាទយើងមានមជ្ឈមណ្ឌលដើម្បីធ្វើជាអាជ្ញាកណ្ដាលទាក់ទងនឹងវិស័យពាណិជ្ជកម្មបាទហើយទី7ហ្នឹងគឺតុលាការបាទតុលាការអញ្ចឹងអាចទៅតុលាការក៏បាទអញ្ចឹងខ្ញុំមានតែប៉ុណ្ណេះទេបាទហើយក៏សូមថ្លែងអំណរគុណដល់អាយដាមលោកជំទាវនិងសិក្ខាកាមយើងទាំងអស់ដែលបានចំណាយពេលយកចិត្តស្ដាប់យកចិត្តទុកដាក់ស្ដាប់នៅអ្វីដែលខ្ញុំបានបង្ហាញបាទសូមអរគុណ
Thank you, Mr. Tori, for that wonderful presentation. It was very informative. Learned a lot. I would just like to do a short question and answer session right now. Just want to open up for 1 or 2 questions. Directed at Mr. Tori. So if anyone wants to take the floor, please unmute your mic and speak. Any questions? I know Rom. Okay.
Hello.
Hi.
Yes, I have a question.
Please go ahead.
In Cambodia.
Yes.
បាទសូមជម្រាបសួរអាយដាមដែលបានបរិយាយរបស់ក្បាយមិញទេបាទប៉ុន្តែខ្ញុំមានសំណួរមួយតាក់ទង
ជំរាបសួរបាទ
ជំរាបសួរបាទខ្ញុំមានសំណួរមួយតាក់ទងទៅនឹងការចុះបញ្ជីហើយនឹង
សូមឲ្យលឺតិចមកបងអូនសូមឲ្យលឺតិចមក
បាទគាត់លឺនៅបាទលឺនៅបាទខ្ញុំអត់ទាន់ច្បាស់បាទអាយដាមបាទតាក់ទងចំណុចមួយដែលថាចុះបញ្ជីពាណិជ្ជកម្មហើយនឹង trademark តើខ្ញុំគឺខាងសិប្បកម្មអញ្ចឹងណាបាទហើយខ្ញុំបានចុះបញ្ជីនៅក្រសួងពាណិជ្ជកម្មតាម KMDG រួចរាល់ហើយបាទប៉ុន្តែចង់ដឹងថាការចុះបញ្ជីបែបហ្នឹងវាអាចជាការពី trademark ដែរទេឬក៏យ៉ាងម៉េចដែរបាទខ្ញុំអត់សូវច្បាស់បាទអធិស្ឋាន
បាទសូមអរគុណបងសំណួរដែលមានសារៈសំខាន់បងបានចុះបញ្ជីក្រុមហ៊ុនប៉ុន្តែមិនទាន់បានចុះម៉ាកទេចុះកម្មសិទ្ធិបញ្ញាទេមិនអញ្ចឹងបងណាបាទអញ្ចឹងត តាក់ទិននឹងការចុះបញ្ជីក្រុមហ៊ុននេះវាមិនពាក់ព័ន្ធទៅនឹងការការពារម៉ាកទេមានន័យថាឈ្មោះក្រុមហ៊ុនបងប្អូននោះមានឈ្មោះណាមានឈ្មោះអីឧទាហរណ៍ថាឈ្មោះ X Y Z អីចឹងទៅអញ្ចឹងការចុះបញ្ជីហ្នឹងគ្រាន់តែជាការឲ្យកំណើតមួយទេឲ្យកំណើតដើម្បីធ្វើអាជីវកម្មបាទអញ្ចឹងរដ្ឋងាយស្រួលក្នុងការគ្រប់គ្រងបាទគ្រប់គ្រងឈ្មោះក្រុមហ៊ុននៅណាយហ្នឹងត្រូវបង់ពន្ធបង់អីចឹងទៅប៉ុន្តែសួរថាតើទទួលបានការការពារ trade name នឹងអត់ឈ្មោះក្រុមហ៊ុនហ្នឹងភាសាបច្ចេកទេសយើងហៅថា trade name បាទអញ្ចឹងមិនទទួលការការពារទេតលបងប្អូននឹងចុះម៉ាកមួយទៀតយល់ទេបងតលតែចុះមួយទៀតបាទបានទទួលបានសិទ្ធិទីបាទអរគុណបង
តើតងរឿង trademark វិញដូចជាបាទខ្ញុំសូមណែនាំតិចខ្ញុំឈ្មោះភិរមខ្ញុំមកពីខាងស្រុកប្រទេសស្រីបាទឃុំព្រៃឃុំខ្នារសណ្ដាយស្រុកប្រទេសស្រីខេត្តសៀមរាបខ្ញុំទឹមតែបើកអាជីវកម្មមួយសិប្បកម្មមួយឈ្មោះថាភូមិចន្ទីបាទជាសិប្បកម្មកែច្នៃក្របចន្ទីអញ្ចឹងបាទអាយដាមបាទអញ្ចឹងទៅខ្ញុំសូមអាជ្ញាប័ណ្ណសូមចុះបញ្ជីក្រសួងពាណិជ្ជកម្មរួចហើយប៉ុន្តែឈ្មោះរបស់ខ្ញុំឈ្មោះភូមិចន្ទីតើ trademark របស់ដែលខ្ញុំនឹងត្រូវដាក់ហ្នឹងគឺដាក់ភូមិចន្ទីដែរឬក៏មិនអាយដាមបាទ
ខ្ញុំខាងមុខខ្ញុំឮថាភូមិចន្ទីឬមិនបង
ភូមិចន្ទីអាយដាមភូមិចន្ទី
ភូមិយើង village ហ្នឹង village ហ្នឹង
បាទ cashew village បាទ cashew village
អូបាទអញ្ចឹងអាជីវកម្មបងអូនដាំចន្ទីត្រូវដែរដាំចន្ទីដែរ
អត់ទេខ្ញុំអត់បានដាំទេប៉ុន្តែខ្ញុំទិញកសិផលជាផ្សេងពីក្របចន្ទីបាទពីកសិករដែលគាត់ដាំនៅម្ដុំហ្នឹងអញ្ចឹងយកមកកែច្នៃបាទអញ្ចឹងខាងខ្ញុំគឺជាសិប្បកម្មកែច្នៃក្របចន្ទីនៅស្រុកប្រទេសស្រីបាទ
តាក់ទិនសំណួរនេះគឺម៉ាកសញ្ញាបងអូនហ្នឹងគឺម៉ាកហ្នឹងវាមិនខ្លាំងទេបងអូនវាមានភាពខ្សោយបន្តិចដោយសារអាជីវកម្មបងអូនហ្នឹងគឺរស់ស៊ីខាងក្របចន្ទីហើយបងអូនដាក់ម៉ាកចន្ទីអញ្ចឹងអាហ្នឹងដូចខ្ញុំបញ្យល់មិញគេហៅ generic term ណាបាទអញ្ចឹងសរុបមកគឺបងអូនគួរតែថែមពាក្យអ្វីមួយម៉ាត់អីទៀតទៅឧទាហរណ៍ថាបងអូនឈ្មោះភិរមអីចឹងបងអូនដាក់ថាភិរមចន្ទីអញ្ចឹងទៅណាភូមិហ្នឹងក៏វាមិនជាខ្លាំងដែរពាក្យហ្នឹងបាទចង់និយាយថាវាពាក្យជាទូទៅពេកដូចជាពិសេសចន្ទីហ្នឹងមកចន្ទីនេះគឺមិនការពារជូនបងអូនទេបាទអត់ការពារជូនបងអូនទេបាទភាគីផ្សេងក៏គេមានសិទ្ធិប្រើដែរហើយចំណុចហ្នឹងដែលថាវាអត់ម៉ាកយើងវាមិន strong វា weak ម៉ាកខ្សោយដូចខ្ញុំបញ្យល់កាលណាម៉ាកយើងកាន់តែខ្សោយយើងមិនទទួលបានការការពារម៉ាកយើងកាន់តែខ្លាំងយើងទទួលបានការការពារកាន់តែខ្លាំងបាទយល់ទេបងយល់ពីរុំ
បាទអាយដាមទទួលបានប៉ុន្តែសុំមួយទៀតអាយដាមបាទដូចជាខ្ញុំចុះបញ្ជីពាណិជ្ជកម្មនៅខាងក្រសួងពាណិជ្ជកម្មរួចហើយ
បាទ
តែថាភូមិចន្ទីអញ្ចឹងតើតើនឹង trademark វិញតើខ្ញុំអាចយកថែមអីមួយលើពីលើនឹងទៀតបានឬក៏មិនអាយដាមបាទខ្ញុំយក trademark
បងអូនអាចថែមដូចខ្ញុំបញ្យល់មិញបងអូនអាចថែមពាក្យអីមួយម៉ាត់ទៅពាក្យដែលញែកដាច់ឧទាហរណ៍ដូចជាឈ្មោះបងអូនអញ្ចឹងភិរមដាក់ភិរមចន្ទីអញ្ចឹងទៅបាទអញ្ចឹងហើយបើសិនជាបងអូនសួរថាចុះខ្ញុំចុះបញ្ជីខ្ញុំបើកក្រុមហ៊ុនខ្ញុំដាក់ក្រុមហ៊ុនខ្ញុំដាក់ចឹងហ្នឹងមិនហេតុអីបានខាងកម្មសិទ្ធិបញ្ញាមិនចុះឲ្យខ្ញុំខាងក្រុមហ៊ុនដូចខ្ញុំបញ្យល់ចឹងគ្រាន់តែជាការផ្ដល់កំណើតឲ្យទេផ្ដល់កំណើតវាមិនពាក់ព័ន្ធខ្លាំងទៅនឹង trade name យើងទេនឹងឈ្មោះក្រុមហ៊ុនយើងទេយល់ទេបងបាទគឺការផ្ដល់កំណើតដើម្បីឲ្យយើងធ្វើអាជីវកម្មបានកាលណាបើកក្រុមហ៊ុនទៅបងអូនមានសិទ្ធិនាំចេញនាំចូលណាអញ្ចឹងវាអត់ពាក់ព័ន្ធទេបាទតលចុះកម្មសិទ្ធិបញ្ញាបាទអញ្ចឹងណាបាទ
ចង់ជំរាបសួរថាអញ្ចឹងបើនេះអញ្ចឹងមាន trademark ខ្ញុំអាចដាក់ថែមឈ្មោះអីទៅលើទៀតបានប៉ុន្តែតើតើ
អត់អីទេ
ឈ្មោះដែលចុះក្នុងបញ្ជីពាណិជ្ជកម្មរួចហើយអត់មានបញ្ហាទេអាយដាម
បាទឈ្មោះហ្នឹងអត់មានបញ្ហាទេសម្រាប់ខាងចុះបញ្ជីក្រុមហ៊ុនបាទអត់មានបញ្ហាទេបាទតែសម្រាប់ខាងកម្មសិទ្ធិបញ្ញាគេមើលលម្អិតបាទគេមើលលម្អិតគេហៅ substantive examination ហ្នឹងគឺការត្រួតពិនិត្យម៉ាករបស់តែម្ដងបើយើងមានពាក្យដែលទូទៅហ្នឹងគេមិនចុះជូនទេបើចង់ចុះបានឧទាហរណ៍ថែមពាក្យអីក៏ដោយមិនមែនតែឈ្មោះយើងទេឧទាហរណ៍ថាឥឡូវបងអូនស្រឡាញ់ចន្ទីហ្នឹងភូមិចន្ទីយើងថែមអីមួយម៉ាត់ទៅដាក់ថាភូមិចន្ទីអីទៅអីក៏ដោយឲ្យតែវិញ្ញាណដាច់យល់ទេបងមិន limit មិនកំណត់ថាត្រូវតែដាក់ពាក្យនេះពាក្យនោះ ឬក៏ឈ្មោះនេះឈ្មោះនោះអត់ទេបាទបាទ
ក្នុងឯកឧត្តមក្នុងករណីមួយថាខ្ញុំយក trademark មួយត្រូវថែមឈ្មោះឧទាហរណ៍ថាភូមិចន្ទីសៀមរាបឧទាហរណ៍អញ្ចឹងតាក់ទងនឹងឈ្មោះដែលខ្ញុំចុះបញ្ជីនឹងក្រសួងពាណិជ្ជកម្មតើខ្ញុំសិនបើខ្ញុំចង់កែអាចបានទេឯកឧត្តមបើសិនកែមកដាក់ដូច trademark ដែរបាទ
បងប្អូនអាចកែបានបងប្អូនអាចដាក់ពាក្យស្នើសុំទៅនាយកដ្ឋានចុះបញ្ជីពាណិជ្ជកម្មកន្លែងបើកក្រុមហ៊ុនហ្នឹងសុំអាហ្នឹងគេហៅកែនាមករក្រុមហ៊ុនយើងប៉ុន្តែខ្ញុំសុំឆ្លើយឲ្យហើយដែរបងប្អូនមិញថាថែមសៀមរាបហ្នឹងក៏មិនងាយចោះដែរបាទសៀមរាបជាឈ្មោះទីតំបន់កន្លែងទេសចរយើងណាបាទឲ្យតែឈ្មោះទីកន្លែងឈ្មោះខេត្តឈ្មោះប្រទេសហ្នឹងគឺច្បាប់យើងគឺហាមហើយបើសិនជាបងអូនអាចដាក់នៅលើម៉ាកហ្នឹងក៏មិនការពារជូនដែរយល់ទេបងឧទាហរណ៍បងអូនថាដាក់កំពង់ចាមអីហ្នឹងព្រោះទីតាំងកំពង់ចាមហ្នឹងក៏មិនងាយចុះបានដែរបាទចុះមិនបានទេហើយក៏អត់មានច្បាប់ណាការពារយើងដែរឈ្មោះខេត្តឈ្មោះទីកន្លែងអញ្ចឹងណាបាទឈ្មោះប្រទេស
បានអាយដាមបាទបានអាយដាមបាទអរគុណច្រើនបាទអរគុណច្រើន
បាទអរគុណបងបាទ
Hey, thank you so much. Yeah.
I have a question.
Okay, sure. Let's be quick. So please go ahead.
ជំរាបសួរអាដាមជំរាបសួរ
Yep.
ខ្ញុំបានចុះ trademark ហ្នឹងតាំងពី2016
បងសុំទោសបងសុំឲ្យឈ្មោះបងប្អូនយើងស្គាល់ផង
បាទខ្ញុំឈ្មោះជាងបូរ៉ាមកពីក្រុមហ៊ុនតាគីមឡុងបាទអាដាមខ្ញុំបានចុះ trademark ហ្នឹងតាំងពី2016ទៅលើជា mark ប្រើទៅលើសញ្ញាផលិតផលហើយដែលបានឮអាដាមលើកមកមិញថាបន្ទាប់ពី5ឆ្នាំហ្នឹងយើងត្រូវធ្វើប្រតិវេត្ត
បាទ
ខ្ញុំសម្គាល់ឃើញថាក្រុមហ៊ុនខ្ញុំបានធ្វើប្រតិវេត្តប្រចាំឆ្នាំជាមួយក្រសួងវិទ្យាកម្មចង់បញ្ជាក់ថាប្រតិវេត្តហ្នឹងហើយជាការបញ្ជាក់ទៅលើការបង់maintain ទៅលើtrademark ហ្នឹងយើងឬក៏ប្រតិវេត្តហ្នឹងសម្រាប់តែការចុះឈ្មោះពាណិជ្ជកម្មប្រចាំឆ្នាំឯអាដាម
បាទសូមអរគុណបាទប្រតិវេត្តសម្រាប់ក្រុមហ៊ុនហ្នឹងមិនពាក់ព័ន្ធខាងកម្មសិទ្ធិបញ្ញាទេបងខាង trademark ទេខាងប្រតិវេត្តហ្នឹងសម្រាប់ក្រុមហ៊ុនហ្នឹងគេតម្រូវឲ្យមកបំពេញរៀងរាល់ឆ្នាំតែម្ដងណាមួយឆ្នាំមកបំពេញម្ដងកាលណាយើងមកបំពេញមិនទាន់វាអាចរងពិន័យអីទៀតតែប្រតិវេត្តដែលខ្ញុំនិយាយហ្នឹងភាសាអង់គ្លេសគេហៅថា affidavit of use or non use មានន័យថាមិនមែនមកធ្វើរាល់ឆ្នាំទេមានន័យថា5ឆ្នាំតម្រូវឲ្យធ្វើម្ដងមកដាក់ពាក្យសុំម្ដងណាបងអាហ្នឹងប្រតិវេត្តសម្រាប់ម៉ាកសញ្ញាណាបាទកុំច្រឡំជាមួយនឹងប្រតិវេត្តក្រុមហ៊ុនបាទមួយរាល់ឆ្នាំមួយទៀត5ឆ្នាំម្ដងបាទយល់
សូមបញ្ជាក់បាទសូមបញ្ជាក់បន្ថែមបាទឥឡូវហ្នឹងខ្ញុំ2016បាទខ្ញុំ2016មកដល់ឥឡូវហ្នឹងវាចូល5ចូល6ឆ្នាំហើយអញ្ចឹងបានថាម៉ាកខ្ញុំហ្នឹងគឺវាត្រូវបើសិនតែមិនមកចុះបន្តទេបានថាវាផុតសុពលភាពហ្នឹងមែនទេអាដាម
អត់អីទេបូរ៉ាបាទអត់អីទេទៅឆ្នាំ2006ហ្នឹងគឺច្បាប់ទុកពេលឲ្យអាចមកបន្តបានណាបាទអាចមកបន្តបាន
អរគុណអាដាមខ្ញុំនឹងទៅបន្តថែមទៀតអរគុណច្រើន
បាទអរគុណ
Thank you so much, Mr. Torit. And as I said, these discussions are the type of discussions we want to have. This is why we do such programs, to be able to bridge that gap, as Dr. Andrew said, and be able to connect people together to learn from each other. So thank you so much for the people that ask questions. Thanks so much, Mr. Torit, for the good presentation. Without further ado, I would like to pass the floor to Miss Tambi Mishra. She's an associate legal copyright officer in the Copyright Law Division of WIPO. That should be presenting on using the work of third parties and the risk of not knowing. Ms. Tambi, the floor is yours. Thank you so much. Tambi, just in case you're speaking, I'm not sure I can hear you.
Hello.
Yeah.
Hello. Am I audible now?
Yeah, you're on mute. So it's
I
waking up.
am so sorry for that. So
No.
as I was saying that hello to everyone, and I'm very happy to be here. I'm from the Copyright Law Division of the World Intellectual Property Organization. I have a tendency to speak a little fast, so for the interpreter, if I do, please let me know, and I will make a conscious effort to slow myself down. I also must start with echoing the sentiments of the esteemed keynote speakers, where they said that the purpose here is to engage and to talk and to have raised questions. Of course, there's a segment devoted to questions, so if any thought or a question comes up in your mind, please note it down, because it's very important, especially for copyright, what I will be talking about, that you engage with this content. What I will be talking about is, and giving you a sort of a flavor of, is the world of copyright, which is the truly a creative element of the intellectual property. So it is distinct from industrial property. Industrial property covers your trademarks, patents, designs, as Derek delved into the principles there. Copyright is separately treated under the umbrella of intellectual property because it's to do with the creative elements. And all of that is truly applicable to the e-commerce, to the electronic commerce environment and the digital marketplace. IP law, and in particular copyright and technology, they are both needs-based. They keep evolving. To just give a purpose to this whole conversation and why you should think about copyright is because let's talk about what copyright is not supposed to do. It's not supposed to influence technological possibilities for the creative expressions or influence the business models that are built on those technological possibilities. It's also not supposed to preserve the business models that are probably built on outdated technologies. We heard Derek talk about how technology outpaces law. From a copyright perspective, I will add that for copyright, law usually precedes, it usually comes before mass adoption of technology. And many times, from a copyright perspective, existing law accommodates new technologies. The purpose of copyright is to work with any and all technologies for the production and distribution of cultural works and extract some value from the creative and cultural exchanges that have been made possible by those technologies, and to return to the creators, to the business associates, and all involved in the creative value chain. So we will, in this presentation, we will focus on, with this perspective, we will focus on a little bit on the international copyright legal framework and the way it applies to Cambodia. Cambodia has recently, the Berne Convention, which is the oldest international copyright instrument, has been put in effect in Cambodia recently, a few months ago. And it's the most fundamental element of a complex structure of conventions and treaties. So we'll talk a little bit about that. And we'll try to identify the core principles which are applicable to the online e-commerce environment. So to break this all down, I thought it would be useful to start off with saying what we plan to understand here. What applies, you may think may apply to the physical world, but is equally applicable to the online world. These are concepts and layers which I call layers to the understanding of copyright. There are works, and this is a legal technical term which I will explain in a little detail. Then there are authors of those works, and then there are economic rights, which are the bundle of rights. That's how you monetize your copyright. That's how you, when you put your works as the author or the owner of copyright online, you monetize it through economic rights. So what I hope to achieve is give a little flavor of what these things are. When you see these images to the right, there are examples of works which were not qualified as copyright works, which is the smell of a perfume or the taste of a cheese, because it was not original. It was not something which could have been objectively perceived. And to your right, you see examples of authors of copyright which were not given protection, or there is a gray area where the painting on the top is created by AI, and there is a big debate on whether there is copyright ownership in a creation of an creation of a work which is created by an artificial intelligence. And of course the photograph is of a macaque who took it himself, so whether the animal is the own author of the copyright work, which is the photograph in that case. So just to sort of put this in perspective, we can talk a little quickly about the international legal framework, where there are several treaties. The Berne Convention, like I said, is the oldest international copyright instrument, and it's still the most fundamental. It contains all provisions which are fully adaptable and applicable to the digital environment, to the electronic commerce environment. So it's still very relevant. It's gone through several revisions over the years, and this is where I try to make good my point about how copyright law precedes mass adoption of technology, because these revision conferences, the last two being in 67 and 71, took into account new technologies, from video technology to cassette systems, home taping, satellite broadcasting, cable television, computer programs. And of course, then in 1996, there were new treaties that came up, and which took into account the internet, the way the internet facilitates access to works. Now we'll quickly jump to understand what are these works that we talk about. Now, it is a technical term, so it's not supposed to be understood in its literal language translation or interpretation. Works are the productions of your creativity. Those are what you create by your expression of your creativity. In Cambodia, this is of course on your screen. You see the definition of works as it's provided in the Berne Convention, and which is fully incorporated in the copyright law of Cambodia, where it says a work means a product in which thoughts or sentiments are expressed in a creative way, and which falls within the literary and scientific, artistic or musical domain. I emphasize product because that signifies what in the Berne Convention you will see here says every production. What does this mean? It means mere ideas are not protected. It's the expression of it. So if you write something on your website content, when you put up literary content on your website, it is, if you think about it, there are concept notes and all that you develop, but if you've written it down, you've developed a tangible product. It's the capturing of your creative expression that matters. It's not about the medium on which you capture it, whether it's on your computers, whether it's on a piece of a paper, whether it's in stone. It's the capturing of that creative expression, but it has to be expressed. It cannot be just an idea. And then when even in the Cambodian definition, they talk about expressed in a creative way. It talks about that talks about originality. So there are a lot of they call it public domain, where there is hackneyed concepts which are for everyday use. Everyone uses it. It's not as if you just took an example from a book and you just used it, reproduced it, that you will get copyright. It has to have your own creative expression to it. The threshold of originality is of course very low. So you don't need to be Herman Melville here, or Charles Dickens, or any famous author. When you write, when you express yourself, when you sing, when you create a computer program, when you do all of that and you express yourself in an original way without access or without copying or and bringing your impression into it, that's what copyright protects. It is very important to understand the concept of originality and the concept which is linked to the concept of work in copyright. Again, when we talk about literary and artistic, it does not mean it's just literary, that is the domain of, say, fiction that is covered, or artistic, which means fine arts that are covered. These are again technical terms, legal technical terms we call them, and it's used actually in the sense of an adjective, where they are used to refer to all languages, all information-oriented productions that are expressed in letters, numbers, or any other symbols. It's irrespective of the fact whether they are legible for everyone or they are coded. That is, they are only available to certain people and by the use of certain equipment. Similarly, the adjective artistic in this context covers all possible modes and forms of expression other than literary, but this covers the entire ambit. In the Berne Convention, there is a illustrative list which you see on your screen, and of course you can protect more works. In the Cambodian copyright law also, this has been mentioned in a similar way. There is also reference to the scientific domain, which does not mean that you are protecting the science that is behind it, but the expression.
ក៏ប៉ុន្តែនេះការពីអំពីការសម្ដែងការគឺជាស្នាដៃដូចតែនឹងសភៅនៅសរសេរអត្ថបទជាដើមគឺថាគេមានការការពារជាសិទ្ធិអ្នកនិពន្ធដូច្នេះហើយនេះគឺជាបំណងពិភពលោកអំពីការការពារស្នាដៃអ្នកនិពន្ធដូច្នេះគឺថាវាអាចអនុវត្តសពទៅក្នុងបរិយាកាសនេះដែលយើងបង្កើតជាស្នាដៃព្រោះនេះជាគំតែជាអ្នកនិពន្ធនេះវាខុសពីបច្ចេកវិទ្យាប៉ុន្តែវាមានកំណត់
Some, as I heard a question previously, so I would want to refer to it, where when you refer to the handicraft industry, that of course also there is an interplay with copyright, which falls under the domain of artistic works, and in certain countries, in certain jurisdiction, they also call it artistic craftsmanship, where you create works with your own hands and there is copyright in it. You can claim copyright in it, and of course copyright is not something for which you need registration. It is, again, that's why it's a different kind of IP from the industrial property, where copyright subsists on creation. So the moment you create an original work, it has copyright in it. So just wanted to highlight that the handicraft industry can also look at artistic copyright, enforcing artistic copyright. This is just a brief flavor of what works are. Let me move to the next slide. And also related to the concept of works, which I thought would be useful to highlight here, is the concept of source code and the object code, because all your technology, all your creations, your website, whether you're creating a website, whether you're creating an app for promoting your products, as small and medium enterprises, whether you're creating, perhaps you're creating drones and using technology, everything is based on the source code. The underlying source code is protected as a literary work. As I said earlier, literary work, it does not need to merit literature, the high threshold of literary merit. But even computer programs hence are, and I may not be able to read it, but because they are expressed as literary works, they are specifically protected under copyright. So even I looked at the Cambodian copyright law, where this is also enshrined. This of course comes with the later copyright treaties, which are the WIPO copyright treaties, which came about in 1996, but Cambodian copyright law seems to be ahead, and because Cambodia has not yet ratified or acceded to the WIPO copyright treaty, but computer programs have been defined in the act, and they so you get protection for copyright. If someone copies your website or content of your website, you can claim copyright protection in the underlying source code. Of course, you have multiple layers of protection there, which will come out through this next slide here, because the look and feel of your website, the way your app looks, is a different kind of work. The underlying source code is the literary work. The website, the look and feel, the interface, the graphical user interface is artistic work. So if somebody copies elements of that, then you approach it from an artistic work point of view. And if someone goes into the, if it is exactly similar, you take the source code and you compare it, and then you say that the source code also has been copied, which is the literary work. So it's very important to understand what these works are, how they are classified, categorized, and what you can enforce when you see that someone is copying your work, or when you want to go online and use some work. You should be mindful of these concepts. Very briefly. Similarly, there are translations and adaptations, arrangements of music. Now, all of this is, of course, these are works of creativity. You create these things, you put them online, you share information. That's why I thought it was important to highlight that it is also protected. Translations are protected as what are called derivative works. So they are derived out of the original works in certain cases. So for making a translation, you need permission from the original authors. So here, if there is some work that you find in English and you want to use it in your language, Khmer, and you want to put it out for your audiences and your business model, that's what it is about, and there is a part of it, you would need permission to do that, although you will have copyright in your translation, quite separate from the copyright in the underlying original work in whichever language. So I just wanted, because this is a very nuanced aspect where there are layers of works in every product, just to be mindful when you're thinking of what use you're making of a work, just to know and slot it properly, I think really helps. It's not about the technical language, it's about knowing when what is applicable. Very quickly, the other thing that I thought which is related to the second concept that I hope to share, which is authorship, which we of course understand as the person who creates is the author. If you create, if you write, if you put something online, if you make an artwork, if you're coding a program, if you are the creator, you're the author. But there are times when you engage someone to do that for you. That is where the transfer of copyright comes into play, which is either through assignment or licensing. But before that, certain jurisdictions also have built in within the copyright laws certain provisions on how and what should be relevant for the transfer of copyright. For instance, in an employer-employee relationship, which is also known as work for hire, there is a presumption of transfer. So if I engage someone to do something for me, if the law provides, if your national law provides, then there can be a presumption of transfer of copyright to you. Of course, there's an element of moral rights which remains with the author, that's not transferable, but for economic rights perspective, you get the copyright and you are the owner of copyright then. So this is also another thing that is important to bear in mind, because many times we hire people to do to create works for us, and if there is no legal presumption in the law, and often that's also it blurs in applicability. One could have licenses and assignment agreements marked out properly with the transfer of what work is being transferred. Very important to identify what rights are being transferred, and of course it's the author of that work, the creator of that work, transferring it. So that these aspects, that's how they translate into action. Also when you're trying to engage with more kinds of activities. Before I jump into the third aspect that I wanted to highlight, which are the economic rights, where all the value of copyright vests, that's what you're actually transferring in these transfer agreements and license agreements. You're transferring that value, the economic value. I'll just address that in a moment. But before that, I thought it would be useful to put all this information in perspective of the core principles of the international legal framework. Now, what does it mean when Cambodia is a party to the Berne Convention? If I'm being very, very simple and in very simple terms, it means that each Cambodian author for their creations, for their works, gets protection in every Berne Convention country. So every country, which is now 183, if I'm not mistaken, countries of the world, you get protection. You get protection. Now here is where this national treatment under the Berne Convention and the copyright legal framework sort of becomes a little nuanced, and it's not. It's very useful to know that you get protected. So for instance, if you went and your work was used in, say, UK, in United Kingdom, then for that work, United Kingdom will apply the law that it applies for its own nationals, plus the minimum obligations which are set by the Berne Convention. So that becomes very important to know what are these minimum obligations, what does the Berne Convention talk about, so that you know that you get this kind of protection, and then you can engage in licensing and assignments and actually generate value for your copyright and for your work. So when someone accesses content on your website from these countries, you know what is being accessed and what you're entitled to. So it sort of adds to your negotiating power, and this is the value copyright generates. I've already mentioned it's a formality-free protection, which means that you don't need to register. You don't need to, it's a lot of countries have a voluntary registration of copyright, which serves its own purpose, but it is not a prerequisite for you to own your copyright in your creation, original creations. Independence of protection is a concept also which once Cambodia as a party to the Berne Convention becomes applicable, where if your work's being used in work, copyright work, your copyright, the creations are being used in a different country, it does not matter whether Cambodia is also giving you, is protecting that work in the same way or giving the same copyright or same layers of copyright. You will be protected independent of that. So the national law of the country in which it is used will be applicable. Just a few things that are important in this, in this e-commerce world where information, the boundaries are blurred, geographical boundaries are blurred. So I thought these would be some key elements to just keep in mind and to talk about further in future conversations. And these are the provisions for formality-free protection and independence of protection. Of course, just by way of an example as to how you use copyright in the online, in the digital marketplace, in e-commerce, you create hyperlinks, you create deep links, you embed your website, your pages, you want people to come there, look at it. All of those constitute, in some jurisdictions it's questionable, it constitutes one of the economic rights under copyright. So what are these economic rights? The most important economic right in the digital environment is the right of making available. Now think of this as everyone accesses online content. So you go, say, on Netflix and you can watch your show at a time and place that you choose as a user. That implicates the right of making available. So that is the right, that's the economic right the creator has. So the creator then licenses or assigns that right for it to be available to the users. So there is a value ascribed to it. Now, because of the business models, the way they've developed, that's one of the most valuable rights that have come about, and it impacts everything, whether it's on your website when you create a link, and if you put that link for someone to have access to the content, the copyright protected work through that link, then that's the making available right that is implicated. And it's applicable obviously in different treaties. Then there is this overall concept of communication to the public. All these rights are trying to communicate your work, your creative outputs, the productions of your creativity to the public. So it has to go to the public, and there it could be through wire or wireless means. I looked into the Cambodian Copyright Act, and it has a definition of communication to the public where it includes both wire and wireless means. So even broadcasting is included. And all of these have separate treatment and separate economic value based on how they are, how they distribute their the creative work. So this is also another very core aspect of the bundle of rights. This is what gives copyright value. So you're making available right, your communication to the public right. This is how it is spelled out in different treaties. Then we will talk about this in a bit. Reproduction right, which is known as the crown jewel of all rights, because every act of sharing your work involves making a copy of it. When you authorize someone to make a copy, or when you take work from an online resource and use it, you're making a copy of it, you're reproducing the work. When you capture the work for the first time in say you make a audio recording of me talking right now, you're capturing what I'm saying in an audio recording. That is also a reproduction, but in copyright parlance that's called fixation. You fix the work. I'm not getting into that because that has its own legal implications, but just to highlight here. But reproduction comes in when you store works in on the cloud, in your servers, on your computer systems, when there is a format change. All these activities, they implicate the right of reproduction. Of course, after that, it depends on how it is transmitted further to the public, whether the communication to the public right comes in, whether making available comes in, that depends. So reproduction includes works in any manner or form. So that includes in the Berne Convention itself, it sort of extended to all forms of digital reproduction when it says in any manner or form. So that's why the from a copyright perspective, the laws have been very technologically neutral because they are not dependent on technology. Copyright works are facilitated through technology. And of course, the other treaties also specifically mention how reproduction rights are fully applicable to the digital environment. And that's what it is. There is another, and this right I put right at the end because it's something that I think is more easily understandable, where when you perform works in public, so if you take a CD and you play it in a restaurant, or when there is a live performance, an artist performs in a restaurant or in a concert, these are called public performance rights. This is yet another economic right in the bundle of copyright, where there are several economic rights, right? And so this is when the public is present right in front of the work. It does not have to be a live performance, but the concept is that the place where the performance is being made is open to the public. Does not have to be, it's not, there is no requirement of public actually being there. It has to be, the only thing that the Berne Convention also talks about is that it shouldn't be a private public. So you can of course play music in the comfort of your house and with your friends and family, but the moment you commercialize it and you open it to a wider audience and there is an element of commerce there, if there is music played online, for instance, so when you have online radio, when you there are of course other rights implicated, but one right that's clearly implicated is the public performance right. So that's what public performance right means, and these are all a part of the bundle of rights in copyright. There is a right of distribution, which is probably the only right limited to the physical environment. It does not extend to the digital environment. So distribution specifically means distribution of copies, so original and copies, through sale and other transfer of ownership. It does not mean that digitally you can distribute, and there are several reasons why this was considered appropriate. And lastly, what I thought I would talk about, which is not related to economic rights, but this is how economic rights can be protected by you on the in the digital environment for your commercial purposes, which are these are digital locks. They are called technological protection measures, or TPMs, as spoken about by everyone. There are essentially two kinds, and I will try to give you some examples so that you understand what they mean. You can either put in a digital lock which controls how others access your work. So you restrict the access to a work, or you put a digital lock on how people copy that work. They may have access to it, but how they copy the work. So for access control, there would be passwords. You could have passwords for them to not even have access to the work. There could be paywalls or subscriptions. There could be registration keys. There could be, you could also have access control, which is limited by time, that someone has access to my copyright original work for 48 hours. Movie rentals, that's how this developed, when movie rentals were given electronically for a stipulated amount of time. You could stipulate, you could limit the number of users. These are all controls that you can bring about for others to access your work. For copy control is things like, so this copy control is where you cannot make a copy as a user. So the creator of the work, the author or the owner of copyright can put in a technological protection measure where they say that this is only a read-only work. Block the downloading of the work, put in watermarks where you cannot copy it. So these are all examples on how you can control the dissemination of your work without your permission online. There are of course, there is a dimension and a balance that is always maintained with the public domain, where public domain comprises of works which do not have copyright in it, which could be your ideas which are not expressed, methods or modes of making something, or mathematical concepts. These are excluded subject matter from copyright, or the term of protection has expired. So these are works that you can freely use, of course. There is a test which is to be applied when you formulate or think of free use, which is called the 3-step test, and it's usually on a case-by-case analysis and mostly covered for commercial users. I think I will stop there. And user-generated content, if it is fully applicable to all that I've said before. So if anybody creates something without the permission of a rightful author or a creator, then of course one has to be careful of it and make sure that there are adequate measures in place. So user-generated content also falls within the domain of copyright. And I think that's where I'll stop. And if you have any questions, please do keep them in mind.
Thank you, Tavi, for that great presentation. With this, we'd just like to move on to the question and answer session. We'd like to move to the question and answer session. So if anyone has any questions, please feel free to take the floor, unmute yourself and ask away.
Thank you so much, Tavi. I would like to ask you one question. In Cambodia, doesn't have a regulation protection in, doesn't have a provision in copyright law regarding the digital design protection. So one is my question, is this the digital design protection is can be protected under in Berne conventions, such as graphic user interface. It's like quite of confusing, like it's similar of industrial design. Could you explain me the distinction between a poor user interface and industrial design, and is it can protection it under Berne convention?
So if you could specify what product you're referring to, then I can probably make this more tailor-made to your specific requirements. What kind of product are you referring to for the design protection?
Oh, sorry. Like icon of the app, the application.
Sorry, the application of?
Application of a financial industry, so that is kind of protection. Like they build the app.
App, like an app.
Yeah, yes.
So, okay, so if I may try to answer this, there are several layers of IP protection there. For you to go see, for copyright, it's easier because you can get the artistic work protected. But what the point is, whether you're trying to monetize it or whether someone is copying it, then it depends on what elements are copied there. From a design perspective, when you talk about design registration, the basic concept for design registration is that it should be registered. And before registration, it shouldn't be prior published or prior registered, right? So protection you get as a fundamental concept applicable across jurisdiction is that it should be new. Copyright is more on originality. So there is always an interplay, there is an overlap, but design protects something which is new, which is registered. Copyright does not protect something which is new or novel, and does not need a registration. So perhaps if the work is already out there, if your app is out there and there was no design registration sought initially, it's depending on what you intend on doing. If you're monetizing it, of course you can monetize it as copyright. You can use design patents, but again, for that you'll have to have a registration for design patents. Derek can get into this also, I'm sure. And yes, so if there are overlapping IPs applicable, yes.
So I'm not clear. Could you explain me like core user interface, like app? So is it can be protected under copyright?
Yes. Simple answer is yes.
But in Cambodia, I didn't see any provision, the statute about the registration of digital design. So is it automatically protection?
Yes. So it's protection on creation. It's the element that you're claiming protection on. If you're claiming protection on the artistic element of the graphic user interface, then that part of it is protected. If you can claim protection on the source code, the underlying source code, of course, as with free work, and the way it looks, you can claim protection on that also. As an artist, it's all falls under artistic works.
Okay, I got it. Thank you so much.
All right, thank you, Lalin, for your question. Please do feel free to reach out to us, obviously, with Mr. Senki, and also you can write to us, and we can have further conversations. We can have expert clinics to really dive into what questions you have, and so please feel free to reach out to us. I'd like to pass the floor to any other speaker. I see Rakim Long, your video is on, so I assume you have a question. Anybody have a question? Okay. Tammy, would you want to expand a bit more about any aspect of representation or any other thing you want to highlight?
Did you ask me?
Yeah.
No, if anyone has any thoughts, I think we can open the floor and try to have a free conversation. There are all questions, like I said, IP is need-based, and the more we talk about it, the more we understand it. So please feel free to talk IP.
Okay. Whilst waiting, anyone with their mics on, anyone wants to speak? You can also speak in Khmer, and our very able translator, Mr. Ben, will translate to English for us. So please feel free to ask anything you want to find out. You can ask about the process of registration or the trademark, anything you want to ask. Derek, Derek, are you here with us? Let's get the comment. Yes, Lalian, I see your mic is unmuted.
Yeah, I have one more question, but I will speak in Khmer.
Okay.
ជំរាបសួរដល់អាយដាមចូលរដ្ឋខ្ញុំមានសំណួរមួយពាក់ព័ន្ធនឹងការ registration trademark នៅក្នុងច្បាប់ស្តីពីប្រកាសបានបរិយានាមនៅក្នុង article 3 បានចែងថាពេលដែលគាត់ register ទៅគាត់ទទួលបានសិទ្ធិផ្ដាច់មុខនឹងប៉ុន្តែនៅក្នុងប្រកាសលេខ0117ដែលជាប្រកាសស្តីអំពីនីតិវិធីសម្រាប់វិញ្ញាបនបត្រនៅការកត់ត្រាផ្នែកមុខសិទ្ធិប្រើប្រាស់ម៉ាកនេះតើវា violate ជាមួយនឹងច្បាប់ស្តីពីការប្រកួតប្រជែងទេ
I'm so sorry. I'm trying to put on my headphones because I'm unable to hear.
Yep. So he referred the question to Mr. Torres. Yep. Bong Torres បងនៅក្នុង Zoom ដែរបងមានparticipant យើងម្នាក់គាត់សួរសំណួរជូនបងអញ្ចឹងបង
Yeah, Ben, we can hear you. We just checking if Mr. Torres, yeah. Or Mr. Samba. Let me just check. Yep. Okay. Please just give us a second. We'll come back and we'll answer that, Lalin. We'll just get the people from DIP. Lalin, we'll come back to your question. Any other questions? Mr. Sankey? Any, please go on.
Yeah.
ទៅច្បាស់ខាង Lalin សូមដាក់មិចឲ្យចិត្តតិច
ចាទទួលបានច្បាស់ទេបង
អូខេពីភាសាបងតូរិតហើយគាត់ចប់ប្រជុំសុំសំណួរម្ដងទៀតហើយគាត់កំពុងចូលមកវិញ ចាពាក់ព័ន្ធនឹងប្រកាសលេខ0117ដែលជាប្រកាសស្តីអំពីនីតិវិធីសម្រាប់វិញ្ញាបនបត្រនិងកត់ត្រាផ្ដាច់មុខសិទ្ធិប្រើប្រាស់ម៉ាកនេះបងតើគោលបំណងនៃការផ្ដល់សិទ្ធិផ្ដាច់មុខនេះតើអាចនឹងមានអ្វីដែលជា contrast នឹង proposal របស់ច្បាប់ស្តីអំពីការប្រកួតប្រជែងទេបងព្រោះនេះបើគាត់នាំចូល product មួយគាត់ត្រូវតែធ្វើ record ដល់នៅ product របស់គាត់ចឹងណាបង ទទួលបានសំណួរខ្ញុំទេបង ទទួលបានហើយប៉ុន្តែបងតូរិតគាត់អត់ទាន់ចូលមកចឹងណាចាំខ្ញុំ check មួយគាត់មកផ្លេតចាំគាត់អាច អូខេឥឡូវខ្ញុំចង់សួរទៅខាង international វិញក៏បានដែរចឹងខ្ញុំសួរសំណួរមួយដែរពាក់ព័ន្ធនឹង transcript ហ្នឹងហើយអាចមានសំណួរផ្សេងអាច move ទៅមួយទៀតទៅអាហ្នឹងចាំគាត់មកវិញចាំខ្ញុំ feedback មកវិញណា Lalin you can speak English yeah I would like to ask one more question regarding the transcript. In Cambodia right now, we don't have any transcript regulation. So, do we have any challenges with the franchise if we don't have a transcript regulation? Because in the agreement of the franchise agreement, one of the clauses they stipulate that they need to transcript without the closure. So is there any challenges for Cambodia with transcript situation?
Tammy, if you're speaking up, I can't hear you. I don't know if the others can hear you. I don't. Derek, can you hear Tammy speaking? Oh, you mean I see your hand is up. Okay, sorry, go
on. Thank you, Rudy, and thank you for the question. To the extent that I understood the last question that was asked about the interface between intellectual property rights and the competition law. Of course, on one hand, you have intellectual property legislation, which essentially it's aimed at providing exclusive rights to the owner, whether it's trademark or patent and so on. But also, intellectual property rights, the purpose of it is to really, especially in the trademark area, for example, is really to facilitate the consumer, decision making in the marketplace, to be able to, identify one product, from the other in terms of its origin, its, producers and so on. On the other hand, competition law is, as the name suggests, is to really prevent anti-competitive practices in the marketplace. And when we look at it on the surface, it looks like both are walking against one another. One trying to provide the exclusive right to the owner, the other one is basically saying that don't preventing any anti-competition in the marketplace. But as a matter of fact, they are in fact they work hand in hand. In fact, they are complementary in many different ways. And the only thing that we need to keep in mind is the behavior of the producers, how they want to dominate the market and so on. So it's really there that the competition law is designed to really prevent those type of behaviors. It's not really against intellectual property right in inherently. They are in fact two distinct type of legislation that is trying to have a common goal of making sure that the the circulation and the trading of goods and services in the marketplace takes place in a very smooth, predictable way as much as possible. So that's just what I wanted to add as far as I could remember what the question was. But if there's the answer is not what is being asked, I'm happy to further elaborate as well. Thank you very much.
All right, thank you, Yamin. Thank you, Yamin. Any other questions? Tam, I don't know if you're trying to say something or...
I was just trying to clarify on the aspect of trade secrets also, that in most jurisdictions, it's not as if it is codified in laws. It is developed through judgments, and the importance of trade secret is that it should truly be a secret and it shouldn't be something that was out there. So that is a fundamental element of trade secret. Not everything can qualify as trade secret. But in my opinion, and we could perhaps, check this out, that mostly it's not codified. Derek, if you have something to add from the American aspect also, because a lot of American trade secrets are famous, right? Like the Coca-Cola, KFC, I think.
Okay, I see one question from Ann Pick. If you want to unmute yourself and speak.
Yes, I would like to say in Khmer, and just to answer to the lady who raised the question regarding the trademark and competition, and a little bit I would like to add about the trade secret. Please let me do it in Khmer. Nhưng some slide get one to sorry. That one to nang panha trademark exclusive rights ដែលបានមកពីការប្រកួតសិទ្ធិផ្ដាច់មុខតាមរយៈ franchise ក្តីតាមរយៈ licensing ក្តីតាមរយៈតាមរយៈdistribution កិច្ចសន្យាចែកចាយផ្ដាច់មុខក្តីដែលយើងបានទទួលហើយដើម្បីចុះបញ្ជីហ្នឹង ជាធម្មតាវាមិនតែបញ្ហាហ្នឹងជួនកាលយើងមានសិទ្ធដែលសិទ្ធផ្ដាច់មុខដោយសារយើងបានបង្កើត trademark ហ្នឹងហើយកន្លែងនេះយើងត្រូវគិតថាវាមានប្រយោជន៍សង្គមមួយដែលយើងត្រូវទទួលបាននៅពេលដែលយើងបង្កើតឲ្យមានសំទោសនៅតែមាននៅតែមានប្រយោជន៍សង្គមមួយដែលប្រសិនបើថាយើងមិនបង្កើតកម្មសិទ្ធិបញ្ញាហ្នឹងទេគឺសង្គមហ្នឹងនឹងមិនមានកម្មសិទ្ធិបញ្ញាឬក៏បច្ចេកទេសឬក៏ trademark ហ្នឹងដើម្បីប្រើប្រាស់ឬក៏ធ្វើអាជីវកម្មទេដូច្នេះនៅក្នុងករណីនេះជាទូទៅគេអនុញ្ញាតឲ្យយើងធ្វើអាជីវកម្មផ្ដាច់មុខតែឯងនៅក្នុងតំបន់ណាមួយឆ្លើយតបថាតើវាអាចប៉ះពាល់ទៅដល់រឿង competition ដែរឬទេកន្លែងនេះគឺដូចខ្ញុំបាននិយាយដោយសារវាផ្ដល់ប្រយោជន៍ទៅដល់សង្គមច្បាប់ competition ក៏អនុញ្ញាតឲ្យយើងធ្វើដែរវាផ្ដល់ប្រយោជន៍ដល់សេដ្ឋកិច្ចនិងសង្គមហើយដែលដោយសារថាយើងធ្វើអាជីវកម្មទៅលើកម្មសិទ្ធិបញ្ញាដែលយើងរកឃើញតែប៉ុណ្ណោះហើយយើងមិនហាមឃាត់អ្នកផ្សេងទៀតឲ្យធ្វើអាជីវកម្មនៅទំនិញប្រហែលគ្នាទេហើយអញ្ចឹងហើយបានជាយើងអាចមើលនៅក្នុងមាត្រា12នៃថាយើងអត់ទាន់ដឹងច្បាស់ថានៅពេលណានៅថ្ងៃខាងមុខថាតើយើងនឹងមានសេចក្តីសម្រេចពីគណៈកម្មាធិការជាតិប្រកួតប្រជែងឬក៏តុលាការពាក់ព័ន្ធទៅនឹងបញ្ហានោះយ៉ាងណាឲ្យច្បាស់លាស់នៅឡើយទេដោយសារយើងទើបតែមានច្បាប់ហើយក៏មិនទាន់មានការដោះស្រាយនៅឡើយដែរក៏ប៉ុន្តែវាជាការសម្របសម្រួលជា conciliation នៃសិទ្ធិដែលយើងទទួលបានផ្ដាច់មុខហើយនឹងដែលយើងត្រូវតែធ្វើមានសិទ្ធិនៅក្នុងការធ្វើអាជីវកម្មហើយក៏ការប្រកួតប្រជែងដែរហើយជាទូទៅកន្លែងនេះគឺគេត្រូវឲ្យសិទ្ធិយើងនៅក្នុងការធ្វើអាជីវកម្មផ្ដាច់មុខហើយអាចរហូតដល់ប្រសិនបើថាករណី patent គឺក្នុងរយៈពេលប្រហែលជា20ឆ្នាំឬ industrial design អី5-10 ឆ្នាំឬក៏ថា7ឆ្នាំក្នុងករណីpatent តូចឬក៏ utility model ហ្នឹង7ឆ្នាំដើម្បីឲ្យយើងធ្វើអាជីវកម្មបន្ទាប់ពីហ្នឹងគឺអាចអ្នកផ្សេងទៀតក៏អាចប្រើប្រាស់អ្វីដែលយើងបង្កើតបានលើកលែងតែ trademark ដែលយើងអាចចុះបញ្ជីទៅហើយយើងប្រើប្រាស់រហូតអញ្ចឹងករណីនេះគឺជាធម្មតាពាក់ព័ន្ធនឹងកម្មសិទ្ធិបញ្ញាគឺគេឲ្យកម្មសិទ្ធិបញ្ញាយើងមានសិទ្ធិនៅក្នុងការប្រើប្រាស់ផ្ដាច់មុខឬករណីខ្លះឲ្យយើងប្រើប្រាស់នៅក្នុងរយៈពេលណាមួយវាអត់រំលោភទៅលើច្បាប់នៃការប្រកួតប្រជែងទេយើងអាចមើលនៅក្នុងមាត្រា12និយាយពីការប្រកួតប្រជែងបានចំពោះបញ្ហា trade secret ប្រសិនបើមានការប៉ះពាល់ក្នុងករណីដែលយើងអត់មានច្បាប់ស្ដីពី trade secret នៅឡើយយើងអាចមើលបទបញ្ញត្តិដែលពាក់ព័ន្ធទៅនឹងការប្រកួតប្រជែងមិនស្មោះត្រង់មាត្រា22និងមាត្រា23នៃច្បាប់ស្ដីពី trademark ដែលនិយាយថាបើសិនបើថាយើងរំលោភទៅលើ trade secret របស់គេជាពិសេសមាត្រា22ដែលមាននិយាយរបៀបជា chapeau ជាទូទៅបើយើងធ្វើផ្ទុយទៅនឹងការអនុវត្តល្អនៅក្នុងទីផ្សារផ្ទុយអំពីអង្គើដែលមានកាតព្វកិច្ចស្មោះត្រង់នៅក្នុងទីផ្សារដោយលួចយកព័ត៌មានគេយកទៅធ្វើស្អីមួយដូច្នេះអាហ្នឹងយើងមានបញ្ហារំលោភទៅលើហើយការប្រកួតប្រជែងមិនស្មោះត្រង់ហើយអាចទទួលខុសត្រូវនៅក្នុងរឿងរដ្ឋវិន័យយ៉ាងតិចបាទសូមផ្ដល់ជាចម្លើយបំភ្លឺបន្ថែមប៉ុណ្ណឹងសូមគោរពអរគុណ
Thank you, Mr. Aaron Pick, who's the president of the Intellectual Property Association of Cambodia. Thank you so much for giving us a good response. Really appreciate your participation and you being on the call with us today. So if are there any other questions anyone wants to ask? If not, we'll wrap up and I'll pass the floor to Mr. Senki. Any more questions?
No more question. Yes, so maybe you can. So before we move on, I want to refer to Ms. Lalin that you asking the question. Hopefully, like Mr. Angpik has a response to your question. And if you still not, hopefully you can join tomorrow too. That we will also have like a speaker from Intellectual Property Department of the Ministry of Commerce will be our speaker for tomorrow too, and you can raise your question about your point too. And so sorry for right now as we contact him and he's busy with another meeting. So hopefully you can join tomorrow and ask him to speaker from Department of Intellectual Property from Ministry of Commerce. So let's move on. Maybe let's start with group photo. Daddy. So I would like to invite all the participants. Can you turn on your camera and we will take a photo together. Daddy, you can start on and you.
Yeah, I'll pass it to Vanessa. Let us know when you're ready. If Vanny, sorry, let us know when you're ready. So we take a group picture.
Okay. Hello, everyone.
Hello, everyone. I see.
Let's wait for a bit more. Great to see everyone's faces.
In one will be ready. Yeah, you can start.
Okay. I'll take it in 1, 2, 3. Okay, another one. 1, 2, 3. Thank you.
Thank you, Vanny. Over to you, Mr. Sankey.
Thank you very much.
Thank you, Daddy. So thank you, WIPO team too. I think I'll speak in Khmer as many participants from Cambodia. So maybe you can listen to our translator. Yeah. ជាបឋមខ្ញុំសូមជម្រាបសួរបងប្អូនអាជីវករទាំងអស់ហើយជាខ្ញុំសូមគោរពទៅលោកជំទាវទឹករ៉េតកម្រងរដ្ឋលេខាធិការនៃក្រសួងពាណិជ្ជកម្មឯកឧត្តមអគ្គរដ្ឋទូតឡុងតាមវិចិត្រតំណាងអចិន្ត្រៃយ៍នៃពាណិជ្ជកម្មកម្ពុជាប្រចាំអង្គការពាណិជ្ជកម្មពិភពលោកលោកជាឡាយជាដែលជាប្រធាននាយកដ្ឋានសហប្រតិបត្តិការអន្តរជាតិនៃក្រសួងពាណិជ្ជកម្មហើយក៏ជានាយកគម្រោង Go for Ecam នៃផ្សារកម្ពុជា យើងផងដែរហើយលោកតូរិតដែលលោកជាអនុប្រធាននាយកដ្ឋានកម្មសិទ្ធិបញ្ញានៃក្រសួងពាណិជ្ជកម្មព្រមទាំង Key Expert និងថ្នាក់ដឹកនាំខាង WIPO មាន Mr. Daddy, Mr. Direct Punhi Kim and Miss Tanvi Mistra and Mr. Tan Yemin and also another delegation from WIPO too and សូមអរគុណដល់ participant ដែលជាតំណាងអាជីវសហគ្រាសធុនតូចនិងមធ្យមក៏ដូចជាអាជីវករផ្សារខាង trade យើងទាំងអស់ដែលបានចូលរួមក្នុងវគ្គសិក្សាដ៏មានសារៈសំខាន់ស្ដីអំពីការធ្វើឲ្យប្រសើរឡើងនៅការប្រកួតប្រជែងនិងការកើនឡើងនៃអាជីវកម្មរបស់អ្នកទាំងអស់នេះដោយការប្រើប្រាស់កម្មសិទ្ធិបញ្ញាហើយអ្វីដែលយើងបាន topic សំខាន់ថ្ងៃនេះខ្ញុំសូមសង្ខេបពីខ្លីគឺយើងមាន topic សំខាន់ចំនួន 4 ដែលបានវាគ្មិនកិត្តិយសទាំង from WIPO ក៏ដូចជា from ក្រសួងពាណិជ្ជកម្មដែលមកពីនាយកដ្ឋានកម្មសិទ្ធិបញ្ញាដោយផ្ទាល់គឺសង្ឃឹមថា participant ដែលបានចូលរួមថ្ងៃនេះបានយល់ច្បាស់ពី topic សំខាន់ទី 1 គឺការ introduction អំពី universe IP មានន័យថាការណែនាំអំពីកម្មសិទ្ធិបញ្ញាដែលគេប្រើប្រាស់ទូទាំងពិភពលោកនឹងមានការពីឈ្មោះទាំងការងារទាំងគំនិតនៅក្នុងបរិបទ digital ហើយនឹង topic ទី 2 ដែលសំខាន់ផងដែរក៏បានបង្ហាញពីអត្ថប្រយោជន៍នៃការប្រើប្រាស់ឈ្មោះក៏ដូចជា logo និងផ្លាកសញ្ញាដែលមានការបែងចែកផ្សេងៗនៅក្នុងផលិតផលក៏ដូចជាសេវាកម្មដែលត្រូវបានគ្រប់គ្រងដោយច្បាប់ទូទាំងពិភពលោកទាំងនៅក្នុងស្រុកនិងក្នុងប្រទេសកម្ពុជាយើងដែរទាក់ទងនឹងការធ្វើពាណិជ្ជកម្មតាមប្រព័ន្ធអេឡិចត្រូនិកហើយប្រធានបទទី 3 សំខាន់ក៏បានបកស្រាយដោយវាគ្មិនយើងយ៉ាងបោះបាយដែរថាតើ what is mean by protect by law តើអ្វីទៅដែលគឺការ protect ផ្លាកសញ្ញាក៏ដូចជាកម្មសិទ្ធិបញ្ញាដោយច្បាប់មាន trademark right នៅក្នុងបរិបទពាណិជ្ជកម្មតាមប្រព័ន្ធ digital ហើយនឹងទី 4 ដ៏សំខាន់ចុងក្រោយមួយទៀតគឺមានការប្រើប្រាស់នៅដោយយើងការរួចចម្លងឬការប្រើប្រាស់រៀនអំពីកម្មសិទ្ធិបញ្ញាផ្សេងឬដូចជាឧទាហរណ៍ដូចជាការ download ជា រូបភាពក៏ដូចជាវីដេអូឬ script ផ្សេងដែលថាបងប្អូនអាជីវករយើងក្នុងការប្រកបអាជីវកម្មយើងត្រូវការ learn ហើយក៏ search ស្រាវជ្រាវតាម Google ផ្សេងហើយអានេះជាអ្វីដែលយើងត្រូវឃើញថាក្នុងការយើង benchmark គឺយើងត្រូវការពារនៅក្នុងប្រយ័ត្នទៅលើថាវាអាចប៉ះពាល់ដល់ copyright របស់គេទាំងរូបភាពទាំង script ផ្សេងអញ្ចឹងអានេះជា topic សំខាន់ដែលសង្ឃឹមថាអាជីវករដូចជា participant ទាំងអស់បានចូលរួមហើយនឹងបានស្វែងយល់ហើយអាចយកទៅប្រើប្រាស់ដោយផ្ទាល់ក្នុងការអនុវត្តក្នុងការលក់ផលិតផលបងប្អូននៅលើផ្សារពាណិជ្ជកម្មតាមប្រព័ន្ធអេឡិចត្រូនិកដែរហើយប្រធានបទសំខាន់សម្រាប់ពេលស្អែកគឺសូមអញ្ជើញឲ្យថ្លែងអំណរគុណដល់ participant អាជីវករទាំងអស់បានចំណាយពេលដ៏មានតម្លៃនៅក្នុងថ្ងៃនេះដែរហើយសម្រាប់ agenda ប្រធានបទសំខាន់សម្រាប់ថ្ងៃស្អែកហ្នឹងគឺមានទី1គឺ how can business in the digital environment divide their logo and sign and how can IP facilitate this អញ្ចឹងមានន័យថាប្រធានបទទី1សម្រាប់ថ្ងៃស្អែកហ្នឹងគឺតើរបៀបដែលbusiness អាចបែងចែកពីអ្វីទៅ logo ហើយនឹងផ្លាកសញ្ញាហ្នឹងតើកម្មសិទ្ធិបញ្ញាហ្នឹងអាចជួយសម្របសម្រួលទៅតាមនឹងតាមវិបត្តិបទហ្នឹងដោយដេញបដិហ្នឹងវាគ្មានកិត្តិយសរបស់យើងនឹងបង្ហាញនៅពេលថ្ងៃស្អែកហើយប្រធានបទទី2សម្រាប់ថ្ងៃស្អែកផងដែរគឺការធ្វើពាណិជ្ជកម្មទាំងសេវាកម្មទាំងផលិតផលនៅលើប្រព័ន្ធអនឡាញហ្នឹងណាតើវាមានការបង្កើន value នឹងទីផ្សារយ៉ាងម៉េចប្រសិនបើបងប្អូនជាអាជីវករអាចប្រើប្រាស់មានកម្មសិទ្ធិបញ្ញាគ្រប់គ្រាន់ដោយមានការប្រើប្រាស់ហើយយើងអាចដំណើរការលក់ដល់យ៉ាងម៉េចអញ្ចឹងវាគ្មានកិត្តិយសស្អែកនឹងធ្វើបទបង្ហាញពីសារៈប្រយោជន៍ដែលថាអាចបង្កើតជា value និងពង្រីកទីផ្សាររបស់បងប្អូនដែរប្រសិនបើបងប្អូនមានកម្មសិទ្ធិបញ្ញាត្រឹមត្រូវហើយប្រធានបទទី4សម្រាប់ថ្ងៃស្អែកដែរគឺខាង WIPO នឹងធ្វើបទបង្ហាញអំពីវា call IP channel stick tool មានន័យថាឧបករណ៍ដែលអាចយើងវាស់វែងកំណត់ដឹងថាតើsource ផ្សេង product description រូបភាពឬក៏វីដេអូផ្សេងហ្នឹងវានឹងយើងប្រើយ៉ាងម៉េចដើម្បីយើងដឹងថាវាជាប់កម្មសិទ្ធិបញ្ញាហើយយើងមិនគួរយកប្រើហើយយើងនឹងក៏មានបទបង្ហាញដោយ speaker របស់យើងនៅពេលស្អែកដែរហើយសម្រាប់ប្រធានបទសំខាន់ជាចុងក្រោយទៀតគឺទី8គឺយើងមាន where to seek advice and assistance from WIPO ដែលជាអង្គការកម្មសិទ្ធិបញ្ញាពិភពលោក The World Intellectual Property Organization អញ្ចឹងសម្រាប់ប្រធានបទសំខាន់ចុងក្រោយហ្នឹងក៏យើងបង្ហាញទៅដល់ participant របស់យើងដែរថាតើតកតងនឹងការធ្វើអាជីវកម្មតាមប្រព័ន្ធអេឡិចត្រូនិកផ្សេងនឹងយើងអាច seek advice ឬក៏ assistant ពីខាងអង្គការពិភពលោកនឹងដោយរបៀបណាអញ្ចឹងសង្ឃឹមថាបងប្អូនអាជីវករទាំងអស់បានចូលរួមថ្ងៃនេះនិងបានស្វែងយល់ហើយនឹងបន្តចូលរួមនៅកម្មវិធីយើងថ្ងៃស្អែកហើយសូមអធិស្ឋានដែរនៅថ្ងៃនេះដែលថាយើងមានអាចឡានអួលពីពេលដំបូងទាំងទៅខ្លះហើយយើងពិបាកក្នុងការស្ដាប់ដោយសារយើងអត់បានប្រើតាមទូរស័ព្ទផងប្រើតាមកុំព្យូទ័រផងអញ្ចឹងការបដូរភាសាវារៀងនៅនេះសង្ឃឹមថាថ្ងៃនេះយើងបានរៀនច្រើនហើយក៏មានអាជីវករយើងច្រើនដែរបានចូលរួមយើងបាន100ជាងហើយ participant ថ្ងៃនេះគឺល្អមែនទែនដែលថាចង់80 ទៅ 90% នៃអាជីវករផ្សារ Cambodian Trade យើងហើយបានចូលរួមក្នុងសិក្ខាសាលាវគ្គទី1ថ្ងៃនេះហើយនឹងបន្តចូលរួមនៅថ្ងៃស្អែកហើយជាចុងក្រោយខ្ញុំសូមអរគុណហើយនឹងជួបគ្នានៅថ្ងៃស្អែកទៀតអញ្ចឹងខ្ញុំសូម give the floor to Daddy maybe ក៏អាចចង់និយាយអីបន្ថែម Daddy I want to give the floor to you maybe you can say something
thank you for that and thank you so much to all the businesses that were here today. Really appreciate you taking out your time. I think to all the speakers who took out time during that day, speakers from WIPO, speakers from DIP, and also the team from Ministry of Commerce, Mr. Lache, Mrs. Senki, Her Excellency. And we'll just wrap it up here. Please, this is just the beginning. Tomorrow's session will dive more into online trading, what we can do to, well, how businesses can benefit from online trading, what IP assets and online trading, So that's what I wanted to say. Thank you so much. Please do look at our links. There are more materials about intellectual property over there. Feel free to message any of us on LinkedIn, email us, talk to Mrs. Senki, give us feedback. Let us know what you'd like to see in tomorrow's session. Let us know what you'd like us to improve, to change, and whether we want us, how we can tailor to meet your needs and meet your questions. And also tomorrow, we'd like to hear more about your businesses. We want to hear more about what you do, how you do it, you know, so we can better, you know, tailor our presentations to answer those questions, you know, and we want to keep it more engaging. I can see Aries Farm over here. Very excited to hear about that business tomorrow, Mr. Shehang. And please join our LinkedIn group, most importantly. We have a LinkedIn group where you can ask any questions you have. And I wouldn't take more of your time. It's been a long presentation, so I'll leave it here today. And thank you so much. And looking forward to hearing your feedback. Please write to us, message us, call us, let us know what you think and how we think we can make this better for you. And thank you so much to Mr. Ben for the invitation. And have a nice afternoon and all the best. Thank you.
Thank you.